Good morning. Welcome everyone to our third annual Developments in Immigration Law Student-Led Continuing Legal Education Conference. My name is Kirsten Yeager, and I am the program coordinator for the Education and Outreach branch of the James H. Binger Center for New Americans. The Binger Center was founded in 2013 with a generous gift from the Robina Foundation, and they ultimately cemented their generosity with an endowment last year. The Binger Center is a very unique place. Our center's students, faculty, and staff collaborate with community partners to provide urgently needed legal services to non-citizens and to educate them about their rights. Our goal is to create an impact both regionally and nationally, and we are doing this by listening to our community and engaging in systemic work. We put together today's event to highlight some of the work of our clinical students. Today we will learn more about humanitarian asylum, migration to Canada, motions to reopen, and bond hearings. So a few logistical things before we begin. We're going to have 4 sessions today with 15-minute breaks, and then we're going to give you an hour for lunch. The CLE codes are on your program as well as on signs at the registration desk. And if you visit our website, you'll be able to access an electronic version of the handouts that are in your folder under the Events tab if you click on Developments in Immigration Law. Since this event is also a learning opportunity for our students, please take a couple minutes after each session to fill out the brief evaluation form. We are starting today with a session led by Alexis Dutt and Kayla Hole. Alexis is a 3L. She's a student director, and Kayla is a 2L, and they're both in the Federal Immigration Litigation Clinic, where they work on impact litigation cases. The Federal Immigration Litigation Clinic is taught by Ben Casper Sanchez and Stacy Toiber, along with Medea Sejo Orozco, Sally Silk, and Graham Ojala Barber. They will be giving an overview today about humanitarian asylum relief with an emphasis on the other serious harm prong. So please welcome Kayla and Alexis.
Welcome again, and thank you so much for coming to our third annual CLE. We are very excited to have you here and excited to share a little bit of the work and the information that we've learned on humanitarian asylum as part of our work in the clinic.
Yeah, the Federal Immigration Litigation Clinic works at the Board of Immigration Appeals, into the district courts of Minnesota and abroad and beyond, and then also at the various circuit courts and occasionally the Supreme Court. What we're discussing today is the backside of that, when occasionally cases are remanded and we continue those litigation efforts at the IJ level. So today we're going to start by providing a little bit of context why now in 2018 we're talking again about humanitarian asylum. We're going to discuss the history of humanitarian asylum, the 2 prongs, severe past persecution and other serious harm. We're going to discuss waiving this as an option if you've had your case already go beyond the IJ level, or if you are preparing your case, how to prevent waiving humanitarian asylum. Throughout, we will be doing hypothetical scenarios to practice applying humanitarian asylum to your case development, and then at the end, we'll do a little bit of question and answer. So one thing we really want to stress is that humanitarian asylum is an option only if past persecution has been established. Now, as you're preparing your application, you'll still want to look into a well-founded fear of future persecution. Now, since we're the first group, general overview, if there's past persecution, there's a rebuttable presumption of future persecution. So you'll pursue that, but then also, after you've established that either there is not a well-founded fear of future persecution or it's a weaker claim, that's where humanitarian asylum comes in with these 2 prongs of severe past persecution or other serious harm.
And one thing to note is that humanitarian asylum is primarily discretionary. So that's why as you look at where this fits, it really fits in the asylum analysis. It's not applicable when you're at the withholding of removal or the CAT stage because it is discretionary. So it comes as part of that initial asylum analysis. And we'll talk a little bit more about that, how that comes into play.
So some context. Many of you who are practitioners in the field are very familiar with this TPS basically crisis that we are in, and that in the next few years, if it hasn't already happened, we have seen end of TPS or an impending end of TPS for many of our clients who have been residing in this country for a long time. In addition to that, backlogs in the immigration court system, for example, at the Fort Snelling Immigration Court, are causing many, many years to pass before your case ultimately gets to a merits hearing in front of an IJ. That means that what might have once been a well-founded fear of future persecution may have changed. Country conditions in that home country may be vastly different than it was when you filed that application in 2000, 2010, 2011. And so humanitarian asylum is an option, especially as it does not seem as if the backlog is going to drastically change in the next few years. So as we're preparing new asylum applications, or as we're getting in front of a judge finally for a merits hearing, what are some things we want to think about with humanitarian asylum as an option? So again, for context and for citations, we have the regs up here for you to take a look at and to make sure you ground yourself in. We're going to keep discussing those throughout, but another look at what we're looking at with this analysis process. Okay, so some highlights that we want to hit. Now, like Kayla mentioned, humanitarian asylum is purely discretionary. So you want to make sure you're providing a lot of evidence in your file for why humanitarian asylum is an option for your client. It is a prerequisite, like we mentioned, is a finding of past persecution. A well-founded fear of future persecution, however, that is not a necessary analysis step. Other serious harm and severe past persecution are separate lines of analysis. You don't need to have both of those for a grant of humanitarian asylum to be an option. But also note that the traditional barriers to asylum are still relevant here. So like Kayla mentioned, this is not in the same line of CAT or withholding. We still have 1 year bars to worry about, and we still have particularly serious crimes, and those are still considerations.
And so as Alexis mentioned earlier, we have a handout for you with all of the citations so that you can reference where some of these key highlights are coming from. And what we wanted to do on this slide is really bring out some of the key things to think about as you're preparing your humanitarian asylum claim. So as Alexis mentioned, that one in the middle, the well-founded fear of persecution analysis not required, that comes from the case SAK at the BIA level. And one thing to note is that we have put well-founded fear in that visual that we saw on the last slide because it is something that you always want to consider as part of your humanitarian asylum claim. However, if the immigration judge does not want to go through the well-founded fear analysis, they don't necessarily have to in order to make a finding on humanitarian asylum. So you could, in essence, skip that step of and I'll just go back to it. You could, in essence, skip the well-founded fear step of the hierarchy that we've created because that isn't necessarily required to go straight to humanitarian asylum. But again, as I mentioned, in order to preserve as many claims as possible, you will want to ensure that you provide evidence of well-founded fear.
Humanitarian asylum finds its origins in a case Matter of Chen. That was a 1989 BIA case that basically recognized that individuals who have suffered this atrocious harm in their home country shouldn't be expected to go back to that country. So the United States has recognized this as an option for those who have had this severe persecution in their home country to remain here in the United States. In 2001, it was codified in the humanitarian asylum in the regulations. And then in 2012, with Matter of LS, was where we saw the development of this other serious harm prong. Now that was also in the regulations in 2001. So when humanitarian asylum was put in the regulations, it did more than just say that people who have suffered this severe past persecution could be eligible. It also added the second prong, but we didn't have until 2012 a real case in front of the board that established what other serious harm could be. We still don't necessarily know firmly what it is, but it's more of a standard that we have to work with.
So with this background, we want to jump into a hypothetical, just with this initial information that you have learned so far, just to kind of get our brains moving this morning. So I'll let Alexis read the hypothetical. This hypothetical is also, I believe, on page 5 of your handout, 4 or 5.
Okay, Hypo 1. Your Ukrainian client was kidnapped and forced into prostitution when she was 12 years old. She was beaten by her captors, and when she fought back, she was locked in a room and starved for days on end. Eventually, after 5 years, she was able to escape. She fled to the United States. Her doctors have told her that as a result of this childhood trauma, she is unlikely to be able to have children. You research country conditions in her home country and find that while police are now cracking down on prostitution rings, a civil war has erupted which has caused mass poverty. Additionally, medical services your client needs to treat ongoing conditions caused by her childhood trauma are limited. So now using this information, if we can have you discuss amongst yourselves, briefly analyze the potential forms of relief available to your client.
And we're going to give you about 2 to 3 minutes just to talk with the person next to you about how you might set up some claims in this context. And then we're going to ask for some volunteers to provide what you guys have talked about. So introduce yourself, get to know your neighbor, and we'll come back here in about 2 to 3 minutes. Right on. We're going all the time. We have until 10 minutes. Yeah. Estimating 5 minutes for the first session. We start talking perfect. And then 5 minutes for the next session. 5 minutes for the next hypo. 10 minutes for other serious harm. 6 minutes for that hypo.
Oh, yeah, we didn't talk about protected ground, so that's good. We can include that in the passive restoration.
Yeah.
I don't think we meant to. Well, the past persecution has to be.
Oh, it has to be. Yeah. So we'll talk about it there. Well, I mean, there's.
Right. My microphone's a little hot. Yeah, like kind of reverbing.
Trying to find a spot where there's some light.
Oh.
Yeah, it's a really bad space for that.
Yeah.
In front of a bright screen and
Well, we can do it at the next hypo.
Should we move on?
Yeah. Okay, we're going to come back together now. I know that was a little short, but we have some more hypos to come, so you'll get some more good discussion coming on here in a few minutes. Okay, so using this fact pattern, what are some of the potential issues, or how might you analyze this case with just the basic high-level information that we've given you so far? Any volunteers? Otherwise, we get to call on people. Any thoughts here? Linus, you're right in the front.
I think we were discussing about the need to figure out whether or not, when she was kidnapped and forced into prostitution, whether that would be past persecution, and then that would require whether it's a particular social group, and what other nexus was coming from. And we were equating this a little bit to the Kasinga FGM type claims. And so we had a little discussion about whether or not simply being Ukrainian, and at that time she was 12, a Ukrainian child would be enough, or we would have to throw other parts to make it into a social group. And that would require more research.
And
then
that,
if we get that as severe persecution, then it seems like at least other serious harm would be available in terms of medical condition and mass poverty. But that would still be pretty difficult.
exactly. So I'm going to repeat that for the microphone and for the recording so everyone else can hear. But that's exactly right. So in this hypothetical, we've set up a fact pattern where the real question is past persecution. So whether or not there even can be a finding of past persecution so that you can then get to humanitarian asylum. And as Linus mentioned, there are some indications in this fact pattern that you could use matter of Kasinga and the FGM cases to identify whether there's a particular social group that this client could fall into, but you would need some more research to understand if past persecution was really viable in this scenario. And then if you were able to get a ruling that there was past persecution, you move on to the other serious harm prong of humanitarian asylum. And again, you might need some more research to understand the country conditions in Ukraine at this time, and we'll talk about that other serious harm prong here in a little bit. But you also might want to set up a claim for severe past persecution. Given her age at the time and the severity of the harm that she went through, you may be able to analogize to some of the cases Alexis will talk about here in a minute, where given she is a child and went through this extreme horror at her age, whether or not there was severe past persecution as well. But again, the key takeaway from this hypothetical is that past persecution, with all of the nexus requirements, is a key sort of barrier to even getting to whether or not you can analyze humanitarian asylum.
Okay, so now we're going to move into talking about that first prong, the more traditional prong, which is the severe past persecution prong. Now, severe past persecution is reserved traditionally for the most atrocious of cases. Now, what does the most atrocious of cases mean? Well, in the past, we've had that be recognized as victims of the Nazi persecution, the Chinese Cultural Revolution, and the Cambodian genocide. Those are all cases that the board and then up into the circuits have recognized as atrocious. But note that this kind of countrywide global recognition of this harm, that's not the key element. It doesn't have to be that the United States has recognized that this is a crime against humanity, or that's not necessary for it to be considered severe past persecution. And so going back to our hypo here, there might be a fight to be made depending on the past persecution finding, depending on your client's injuries and what she's experienced and the emotional trauma, that it could qualify as a severe past persecution. So it's certainly something to argue. It's not a laughable argument by any means. The courts have recognized persuasive evidence of severe past persecution to be ongoing extreme torture. You'll see in your handout we have different citations for cases that we've pulled where they've recognized this as severe past persecution. They're long-lasting mental or physical effects. Now, there's a circuit split on this. Some circuits recognize that that's a necessary element, that there has to be some sort of ongoing harm that your client is currently experiencing, either mentally or emotionally or physically, that there's some sort of disability there. And then there's concept of extraordinary suffering. Like a lot of things in immigration, the standard for severe past persecution is kind of when the judge sees it. They know it when they see it. And so layering as much of an analysis, getting medical reports, psychological reports from psychiatrists or counselors, those are going to be what's really important for this prong.
So with that overview, we're going to move into hypothetical 2, which should be on the same page as hypothetical 1 in your handout.
Okay, hypo 2. Your Tutsi client fled Rwanda in May of 1994. Her family was murdered by Hutu rebels, and she escaped by pretending to be dead. She came to the United States and immediately sought asylum, but her case has been pending ever since. She showed you the scars on her torso from where the rebels stabbed her, and she told you that she has infrequent nightmares about her experience in Rwanda. Now, the first thing we want you to think about is what analysis would you go through to establish that your client is eligible for relief, and what additional information would be helpful for you in analyzing this case.
So again, take about 2 to 3 minutes, talk to the person next to you, and analyze the questions that Alexis was just mentioning that are also on your handout.
We're going too fast.
No, we're good because
Right. That's true. A lot more to work through there. With the stand this close to the desk, it'll feel as like I know under. Because this is gonna trip me. This is a different photographer. It's not the Eagle Jacket guy. Pretty interesting.
Okay, I think we're good.
So.
Okay, we're going to come back together. I know that was a little bit shorter, but we want to make sure we're staying on time. So I hope this is giving you a feel for what it's like to be back in law school. I know at least in my immigration classes, we're going through a lot of hypotheticals to actually get the practice of applying the law to specific cases, which I always find is really interesting. So hopefully you're finding that as well. We feel like it really solidifies what we're learning. So with this hypothetical, who wants to take a stab at the analysis that you would go through? Any volunteers in the audience? Yes, I see right in the back. Thank you.
Yeah. Okay, what I would want to know about her is what kind of psychological assistance and whatnot she might have gotten here to get to the point at which she was only having infrequent nightmares. And also whether she's minimizing, because sometimes people will kind of shove stuff under and minimize, and I would wonder whether Centers for Victims of Torture might be helpful at doing a current psychological on her to see whether that's really accurate.
Yeah. So I'm going to take a minute and just to repeat that for the microphone to make sure we capture that. So 2 really important points there. The first is ensuring or trying to understand the type of psychological trauma that she currently has, understand if there's any medical resources that could validate the trauma that she's going through, and then also understanding whether she's minimizing the experience and making sure that the things she is telling you are the full extent of what she's experiencing and that there isn't more there. So maybe the Center for Gender and Refugee Studies might be able to help with some background information. And then did you also mention potentially providing medical resources to do an assessment as well?
And also, I mean, she may or may not be, she may be in ongoing therapy or something like that and have not even mentioned it because of the stigma.
Absolutely.
Because you're looking at some cultural issues there. Though definitely, I'd say, past persecution is a slam dunk.
Yes, past persecution is a slam dunk here, and exactly to your point, one of the things you'd want to understand is whether or not she's in ongoing therapy and whether or not there are cultural stigma issues with her talking about the trauma that she experienced, whether or not there's issues in her current community that she's living in that have led to sort of continuing of this trauma, or on the other side, repressing these memories to some extent. So past persecution is a slam dunk. So what would we go through on next in terms of past persecution? Because there's no ongoing genocide in Rwanda, so country conditions have changed. We aren't really looking at well-founded fear of future persecution given this fact pattern. So someone else want to take a stab at what we are looking at here? We've kind of alluded to it. But it's necessary to go to that next step of the analysis. Someone on this side of the room. Kelsey? Next prong in the analysis.
Sure. So we talked about past persecution, and we talked about
Severe past persecution.
Oh, yeah.
So, yep. So the more traditional prong of the humanitarian asylum analysis, severe past persecution is what we'd be looking for in this analysis. Given the harm that our client suffered, as was mentioned before, past persecution is a slam dunk, but with no well-founded fear claim, given this fact pattern, there may be other information that you'd want to look for as to whether there is well-founded fear to always preserve that claim. But from a humanitarian standpoint, you'd want to look at severe past persecution. And as Alexis mentioned, there's evidence here of civil strife at the time that she was in her home country. There's mental or continuing psychological effects. You may be able to find even more information given this fact pattern, but what you'd really want to dig into here is how extreme was this harm and was this persecution that she suffered, and then make that your claim for the discretionary relief of humanitarian asylum.
Absolutely. This would be a case where there is this global recognition of this being an atrocity that occurred in Rwanda. So that is a helpful fact in analyzing the severe past persecution. I mean, the fact that you could probably, even without her necessarily having been in the house when her family was killed and having to play dead, I mean, that's an exacerbating factor that would make the severe past persecution even more of a stronger argument. But certainly being a minority persecuted group, having her family be attacked and killed. I mean, that makes this a pretty strong claim for severe past persecution.
So now moving on, oh, yes, I see a question in the back.
A follow-up question on this hypothetical.
Yeah.
And that is, as you're making the argument on any kind of continuing harm or for humanitarian, emphasis on humanitarian, is that where one would bring in if it's, for example, ongoing counseling or medical treatment or something like that, that is keeping their psychiatric condition or whatever at bay, and that wouldn't be available in their home country? Would that be something we bring in under the humanitarian thing?
That's a great question. So the question is, when would you bring in the psychiatric care and the continuing mental anguish and the lack of those available resources in Rwanda? That's a great question. So we do have these two prongs for humanitarian asylum, which is other serious harm and severe past persecution. Now, those get a little muddied in what evidence you're going to be producing. It's not necessarily going to be a clear, like, this evidence fits into other serious harm, which we're going to just about to switch into, and this evidence fits into the severe past persecution. I would certainly get those reports and argue them for both, because you might have a judge who's more sympathetic to this ongoing. You obviously have a lot of experience with working with clients with limited resources and knowledge of your home country and their home countries, and so that will be relevant for the ongoing harm. So if she's continuing to have severe psychiatric consequences of her being murdered and almost being murdered, and her family being murdered in her home, that's certainly going to push things more towards a severe past persecution, but it would also be relevant in the analysis for other serious harm. So I would absolutely argue it in this element.
Does that make sense? Does that answer your question?
Great, thank you.
Fantastic. And I see one more question. We'll take it right now, given this section we're on.
Do we treat this as what was personal to her or what the cultural conditions were in her country? And is it necessary to show that things have not changed there?
So for severe past persecution, that's not a necessary element to show that it's ongoing necessarily. That's the nice thing about humanitarian asylum as an option, is as opposed to like a well-founded fear of future persecution and that element, humanitarian asylum doesn't require that same level of continuing civil strife for the severe past persecution prong. It's helpful for other serious harm, but it's not necessary for a severe past persecution.
What about the first part, where she obviously had severe personal trauma, and she's the client.
Personalized.
Yeah.
So is that what's necessary, or is it, do we have to establish a cultural thing with regard to it was a wide genocide that was taking place?
So that's a really good question, and I'd say in the case law that we've provided you, in the case law that we've seen, there always has been that personal element where your client as an individual has been persecuted. But I think that you could make the argument that your client saw the genocide and was impacted emotionally or mentally, and then make that sort of psychological claim that your client would be psychologically harmed to be returned to this country where they experienced such terrible emotions and saw such terrible things going on. So while the case law shows that it has been personalized, I think you can make that argument. We just haven't seen it in the precedent that we have cited and that we've been looking at, but that doesn't mean that there's unpublished cases that don't show that.
So is the government going to argue that the Hutus or whoever, that the Hutus are out of power, they're not doing this anymore?
Probably.
So that's exactly, as you're thinking about the analysis, and this is really important because we want to make sure that you understand, first and we'll go to the next slide to help visualize this. First, you have past persecution.
I have to tell you, you speak loud, faster than I can listen.
Oh, I'm sorry. Thank you for that feedback. I'll slow down. So first you have past persecution, and then as you take a look at the well-founded fear, ongoing terrible conditions or ongoing civil strife of the same kind that gave rise to that past persecution. So the past persecution creates the rebuttable presumption that you will have a well-founded fear, and showing that you would not be able to internally relocate to your country, or that the government was an actor in your past persecution sort of helps you with that well-founded fear claim. So the information that you're providing, if we were to change this fact pattern and the Hutus were still in power, would provide you with evidence that that past persecution has not been, or the well-founded fear presumption has not been rebutted. So essentially, you would argue well-founded fear. What we're saying is that if that well-founded fear has been rebutted, or if the claim is a little more challenging because of the nexus element, that you still definitely want to argue well-founded fear, but you also want to argue in the alternative humanitarian asylum. And I think that this is going to lead to some more questions, but we want to make sure that we are staying on time. So if you could hold your questions till the end, we promise to leave about 5 to 10 minutes for questions at the end. But please write them down because we do want to be sure to get to all of them. So as Alexis mentioned, the second and the less frequently used prong of humanitarian asylum is this other serious harm prong. And when we think about other serious harm, as Alexis mentioned, it was created in the regulations of 2001 to be this forward-looking analysis. So you can think of other serious harm. I like to think of it as similar to well-founded fear, because you are showing all the future harm that would happen to your client if he or she were removed to their country. However, one of the benefits that we'll see is that you don't have to show nexus. So when you think about other serious harm, as I just mentioned, it doesn't have to be tied to a protected ground. And that's because this is discretionary. So you have already shown that there was nexus in the past persecution. The government has now rebutted potentially that well-founded fear, or the immigration judge wants to move on to discretion and look at humanitarian asylum. And you take a look at all of the serious harm, the other harm, that could befall your client in his or her home country. So no nexus is required. That's really huge for all of us that have struggled to find whether or not there is a nexus to future harm. This gets rid of that requirement. So any of the gang violence that your client may or may not be experiencing in Central America can now be used. Anything where the government has said that's not a particular social group because of all the elements of particular social group have not been met, but yet you have shown persecution to some extent. All of that can now be used in this prong. So it really kind of opens the floodgates of harm that you can show your client would experience in their home country. The other piece is that there only need be a reasonable possibility of other serious harm. So this doesn't mean that it has to be the same harm that your client experienced in their past that gave rise to their past persecution claim. It can be completely different harm, and there only need be a reasonable possibility that this harm would occur. And one of the keys is that in the regulations, it actually states that reasonable possibility should be consistent with this well-founded fear standard, and it actually cites Cardozo-Fonseca, which leads us to believe that it should be a 10% standard. So definitely use that regulation if there is any pushback from the government on what reasonable possibility means, because it is explicitly laid out there in the regulations for you. Yes, I see a question right there.
So I may have missed this, but
Yeah.
don't we have to prove a government connection? I mean, there's a lot of serious harm that goes on in gangs, but that's not going to qualify.
No, so you don't need to prove a government connection. That's a really good clarifying point. For this other serious harm, and we'll get to some of the examples that you can show, but there does not need to be a government connection to other serious harm. It's simply any other harm that your client may experience in their home country. And so that is, as Alexis mentioned, the seminal case for that is matter of LS. And as you look at all of the different harms that are laid out in matter of LS, you actually can use a wide variety of other serious harm, which is why this is such a valuable tool and why we and probably the board are shocked that it's so underutilized. And there isn't a lot of case law out there on this prong. But what there is has shown that truly any other serious harm can be utilized in this space. So good clarifying point. So the one caveat to that harm that I talked about is that it must rise to the level of persecution. But you can use all of the harms in the aggregate to get to persecution. So each individual piece of the harm does not need to equal persecution, but as you look in the aggregate, as you look at the totality of the circumstances, as the board says in matter of LS, you have to get to persecution. The other consideration, again, for matter of LS, is that harms and conditions faced by large segments of the population should be considered. So your client doesn't necessarily, again, have to have suffered this, but if there's evidence that he or she may suffer it because large segments of the population would suffer it, and your client would be part of that large segment, then that harm can be considered. As well, on the flip side, if there are harms that large segments of the population do not suffer, but your applicant should uniquely or would uniquely suffer, that can also be considered. So really, this is a wide open space when you're looking at harm. So you want to get really creative about the types of harm that your client may suffer, either because they're going to that country and there's evidence from country conditions research that other individuals have suffered that harm, or because of the unique circumstances that your client is situated in, because of those unique characteristics that your client would suffer. So based on some of the case law, evidence of other serious harm includes civil strife. Again, this is because if there are wide segments of the population that are experiencing this harm, your client would likely suffer this harm as well. Ongoing human rights abuses, for the same reasons. Extreme economic deprivation beyond economic disadvantage, and that's explicitly stated by the BIA in matter of LS. So as you're looking at extreme economic deprivation, look at how your client is currently situated and how your client may be situated if he or she were to be removed to their home country. What advantages do they have here, or what disadvantages do they have here that would or would not be reflected in your home country? For example, is there a certain education level that would mean your client would be practically unable to find a job in his or her home country? Or is there a specialized skill set that your client has that would not be applicable in your client's home country? Would your client's family not be able to send your client money in their home country? So what are all of those surrounding circumstances that may lead to extreme economic deprivation? Again, the severe mental and emotional harm or physical injury comes into play here. So as you're thinking of severe past persecution, also look at all of those injuries and the potential mental suffering or physical suffering, and use that for your other serious harm claim as well, to show that those harms are ongoing and that physical or emotional trauma has not ended and would continue in your client's home country. You may also want to show that there isn't treatment in your client's home country. As one person alluded to, if there's not treatment in your client's home country, he or she may continue on with that suffering. So you'll want to look into what the situation is in your client's home country, as well as what their current situation is here. The possibility of being murdered, that's fairly self-explanatory, as well as, again, I mentioned medical care or medications. And there's a case that we cited in the handout where simply not being able to access medical care for a treatment was a reason to grant a claim of other serious harm. So the part of other serious harm that we haven't seen is well litigated, but we believe, basis the case law, is an applicable claim, is what the government likes to call bootstrapping. So this is taking the harm that you may use in a cancellation of removal case, so harm to others other than your applicant, but then reflecting that back on your client and showing how others' harms could impact your client. So basically how your client's family or your client's close friends would be impacted and devastated, and how that harm would mentally or psychologically harm your client if he or she were removed. So you must tie that harm back to the applicant. It's not discussed by precedential decisions, but we feel that it is evidenced by the matter of LS, especially because you are tying it to psychological harm that would be new. So one example is if your client is the primary breadwinner for his or her family here in the United States, they have emotionally supported their children or their U.S. citizen spouse, and the U.S. citizen spouse or child would be, or potentially even any child or family member, they don't necessarily have to be citizens in this example, but their child or family member who is staying here in the United States would, or even moving to their home country for that matter, as you think through the analysis, but those individuals would be harmed because of your client being deported, and your client would then feel responsible or guilty or saddened or afraid. Any of those psychological fears or psychological harms because of that removal could then be used. And so, as was mentioned earlier, you would likely want to get medical reports or a psychologist to show that your client truly would experience these fears and these harms and has anxiety about these harms occurring in their home country. But you also could use your client testifying on the stand potentially to show that he or she is afraid or, again, afraid or sad or guilty about these specific things happening, because in matter of LS, psychological harm is a basis for other serious harm. So if you can show that those harms are reflected back onto your client, this can be a basis for other serious harm.
I just want to really stress the fact that those of us who have been frustrated when preparing waiver applications or cancellation applications and feeling limited by harm to a U.S. citizen, I just want to really emphasize that that's not necessary here. It's not harm that only citizens who have other grounds for relief. And so think broadly, think about parents, other people in the community that this person would be potentially taking jobs away from if they have a business in that community. I mean, and the anguish that your client will feel because of leaving behind all of those people, that's a broad definition.
So we're going to move on to our next hypothetical, but given how we are on time, we will answer a few questions after this hypothetical, if you have some, about other serious harm, just to make sure that we're fully articulating the analysis that we believe is evident given precedential decisions. So that said,
Hypo 3, okay. In 2010, your Chinese client was forced to undergo an abortion when she and her husband were unable to pay the fine associated with violating the one-child policy. She was 5 months pregnant when the procedure was carried out. As a result of the trauma, her marriage deteriorated and she and her husband divorced. Your client had family in the United States and entered with her first child on a B2 visitor's visa. While here, she filed for asylum. After about a year, she met and married her second husband, who has temporary protected status. They have one child together. After interviewing your client, you find she has been diagnosed with asthma and has converted to Christianity. You research current country conditions in China and see air pollution is a serious risk. Additionally, some provincial governments, have removed crosses from churches, and the central government has tightened regulations on religious freedom, intensifying punishments for unsanctioned activities and increasing supervision of certain groups. Your client completed secondary school in China, but she does not have any further education. She has a specialized job in the United States, and it is unlikely that she would find similar employment in China. With this information, what forms of relief are likely available for your client?
so again, take a few minutes. We'll give you about 3 minutes or so. We'll see when the conversation starts to die down. But discuss with your neighbor, preferably a new neighbor so that you can get to know someone new. If you could turn the other direction, but make sure everyone stays included. Introduce yourself and talk about what some of those claims may be that your client may have given this fact pattern. Okay, there seems to be a lull in conversation. So we're going to bring everyone back together. And I know it's early in the morning, but we still want to try to take volunteers before I start to call on people. So, what's the first step in this analysis? And we really want to make sure that this is clear. So, we're going to go through the analysis step by step. What's the first step in this analysis that people went through? Yes, I heard it up here. Past persecution. So whoever said that, would you mind reiterating or talking just a little bit about the past persecution you found in this scenario? Yes, thank you.
I said it, and I'm not an attorney, so I have no right to answer this.
We're not either, so.
I'm a healthcare provider. But, to me, it's pervasive, but because it's so pervasive, I don't know how somebody gets an asylum claim, because they're doing this to everybody, and are we just opening our doors to anybody who was forced to have an abortion in China? So I don't know, but that's the first place.
So the answer to your question is yes. Statutorily, there is a right to past persecution based on asylum claims, there is past persecution for asylum seekers from China who provide evidence that they have a forced abortion. So statutorily, we get to past persecution here. We have provided some evidence where even if that wasn't a statutory presumption, we could argue that there was past persecution based on a particular social group or potentially based on her religion, her beliefs, or political opinion, I think is where the abortion statute actually came from, was political opinion. But past persecution is clearly found in this example. So what is the next step in the analysis that you as a practitioner would want to go through? Yes, thank you.
I would wonder, with China being such a big country, talk about future risk. Are there places in China where Christians are not being persecuted, where the air pollution is not that great? something, I would wonder what the law and the fact.
That's a great point. So the next step in the analysis is, as a practitioner, you would want to argue well-founded fear of future persecution. So you would go down the hierarchy, the visual that we've been showing, and argue that there is a well-founded fear of future persecution based on some protected ground. What the protected ground is in this circumstance may be religion, potentially. It may be political opinion if you question your client a little further and find that she has some strictly held beliefs. But as you look at well-founded fear, to your point, the government could likely rebut this presumption of past persecution. And so as you think about what the rebuttal may be, it could be internal country relocation. It could be changed circumstances, because in China, I do not believe that they are the one-child policy is no longer changed, and I don't believe that they are doing forced abortions at this point. So the government would likely argue that well-founded fear is not an option. So then you would go to the next step of the analysis. So can someone help us out with what the next step in the analysis would be? I kind of heard some discussion up over here. Yeah, so we would look at the two prongs of a humanitarian asylum. And you're exactly right, we would look to other serious harm. What types of evidence of other serious harm do we see here in this example?
Air pollution.
Air pollution,
Perhaps inability to find employment.
correct. Inability to find employment,
We don't know what the situation would be for her second husband.
correct. We don't know what the situation is for her second husband.
And as we already talked about, we don't know how important Christianity is to her, or how she might be affected.
Potentially religious persecution. So there are a whole host of other serious harms, as you alluded to, that she might experience if she were returned to China. So you would want to go through and explore, using country conditions evidence, as well as her own personal testimony, what those other serious harms may be. You also would want to look at severe past persecution. Again, you don't want to waive any of those claims, and you might want to show the trauma that she experienced through this forced abortion, and whether or not you could argue that the harm was so severe that she should get the benefit of severe past persecution. That may be a little harder claim to make, but you would still want to argue that there was severe past persecution. So the next step, as you think about the analysis, you want to ensure that from the very beginning you haven't waived your claim to humanitarian asylum. And as we say up on the slide, there's sort of two schools of thought on this matter, or two different ways that the courts have approached this. The first is that humanitarian asylum is an integral or a natural part of the analysis. That, as we have been showing on our hierarchy, humanitarian asylum should automatically be analyzed by the immigration judges, and for that matter, the Board of Immigration Appeals and the circuits, when you have laid out a claim for any asylum. The other school of thought is the school taken by the Eighth Circuit. So as practitioners in the Eighth Circuit, you want to be aware that the Eighth Circuit has held your claim must be explicitly raised by the applicant. So if you do not provide evidence or do not raise a claim of humanitarian asylum, the Eighth Circuit generally will look at that claim as waived, as if you are not eligible for humanitarian asylum because you did not provide evidence of that claim or you did not argue that claim.
Or you got the case later and the client has already gone to an IJ and you didn't develop that case at the time. Yeah.
Yeah. So I'm a visual learner, so we've provided another graphic. The first graphic is what we have been showing you all along, and that is what we believe basis the regulations, basis the board's opinion in matter of LS, and also based on some very explicit verbiage in the First Circuit that we provided in your handout. It's how you should treat humanitarian asylum. That as long as you have evidence of humanitarian asylum in the record, the immigration judge should be analyzing that claim after the well-founded fear of future persecution has been rebutted by the government. However, as we mentioned in the Eighth Circuit, they look at this as two separate lines of analysis, where you look at past persecution, well-founded fear, and discretion, and then you also look at humanitarian asylum if you, as a practitioner or if your applicant has argued humanitarian asylum. So as a best practice, you always want to create a record on past persecution. As Alexis mentioned, if your client has provided a record before you were their attorney that has some evidence of past other serious harm or of severe past persecution, you may be able to argue that the evidence was in the record and your client has not waived their claim to humanitarian asylum. But you always want to, if you're taking the case on from the beginning, make sure that you argue humanitarian asylum should be considered, at least in the alternative. The other area where we see humanitarian asylum basically being waived is where your client either doesn't have a strong past persecution claim, or you know that the government is going to rebut the past persecution claim because country conditions have changed or because internal relocation is possible. So past persecution isn't even argued. And as we've said from the very beginning, if there is no finding of past persecution, you can't get to humanitarian asylum, because per the regulations, humanitarian asylum is only considered after a finding of past persecution. So this is why it's critically important to ensure that even if you don't believe your client has a strong past persecution claim, or if you don't feel the need to argue past persecution, you always want to ensure that's available so that your client could have a basis for humanitarian asylum in the future. So this is to say, especially with some of the older cases, past persecution may have been shown, and as Alexis was mentioning at the very beginning, especially clients with TPS or who have very long asylum cases, they probably won't get the rebuttable presumption, or they won't win on well-founded fear. But if you can show that there was evidence in the record of past persecution, even if, especially in some of these older asylum cases, if a finding of past persecution was not made but could have been made by the immigration judge, you will want to argue that there was past persecution and that it was all but given. So the prior immigration judge or whoever it was that made the earlier finding basically assumed past persecution to reach well-founded fear. So you will always want to go back and try to make that argument for past persecution so that you can preserve that humanitarian asylum route.
So we're running a little low on time, so we're going to basically go through this fourth hypothetical, and then we'll walk through our analysis rather than having a discussion on this point, and then that way we have a time for a few minutes of questions here at the end. Okay, so your client is a Mayan Guatemalan. At the end of 1994, when he was 17 years old, your client's village was raided by the Guatemalan army. He remembers hearing government officials yell, "Your kind is not welcome here, we are going to get rid of you." The army killed your client's father in front of his family, and your client was dragged to a jail where he was beaten and detained for approximately 2 weeks. At the beginning of 1995, he fled to the United States. After he applied for asylum with the assistance of a notario and received his work permit. After receiving his work card, he moved to California. For unknown reasons, he was never interviewed for his asylum case by INS or USCIS. Now in 2018, he has received a notice of his interview with an asylum officer. He went to his AO interview pro se and tells you that the interview lasted about 10 minutes. His case has been referred to removal proceedings. Your client, who is now in his 40s, has a wife and 3 U.S. citizen children who have never been to Guatemala. Your client has been employed as a mechanic for the last 20 years and now manages his own garage. Your country condition research shows that nearly 60% of the population in Guatemala lives below the poverty line. Violent crime and corruption are rampant, and Mayans are still discriminated against in many aspects of life. So how would we analyze this case, answering our own question? You'd want to start with asking whether or not this is a case, obviously, for past persecution. His family was killed. They would have the connection to the protected ground as a minority group. So the case for past persecution is very strong. Where we would then proceed to well-founded fear of future persecution. Situation in Guatemala has improved, relatively speaking, at least in reference to this particular incident. And so there's likely that the presumption would be rebutted. Looking at severe past persecution, your client was only detained for about 2 weeks, which is probably what the government would argue. That case law has shown that it has to be, there's no clear guideline on how long you have to be detained for it to be severe past persecution, but the cases where we've seen it granted versus those where we haven't, it's typically something more than a month and certainly longer than a few days, which for those of us thinking about severe past persecution is a tough thing to overcome. I'm going to move into other serious harm.
And then, as Alexis mentioned, we'd also look at other serious harm and take a look at all of the country conditions in Guatemala at this current point in time. So since you have a finding of past persecution, since you have basically a rebutted presumption of well-founded fear, you would then move to severe past persecution and other serious harm. So for other serious harm, whether or not there are deplorable conditions or just harms that can be aggregated in your client's home country. So in this example, you'd want to talk about poverty and how 60% of the population is currently in poverty. That's higher than this 10% reasonable possibility standard that we mentioned at the beginning. So there on its face, you may have some persecution, some harm resulting in persecution for extreme economic deprivation, but you would also want to aggregate what conditions would your client face. So violent crime and corruption, you'd want to show that he was still discriminated against based on his ethnicity, and you'd probably want to do some country conditions research to back up that Mayans are still discriminated against and get some concrete examples around how that discrimination has occurred and affected other individuals' lives. And you also might want to try the bootstrapping argument, given that he has a U.S. citizen wife and children, and show the emotional harm that he would go through if his family was exposed to those conditions in Guatemala, or if he had to leave his family and how he would suffer being separated from his family.
So this is an important one where we just really want to stress to not give up on a past persecution argument. This is one where your client's in front of you in 2018 and you know as a practitioner that Guatemala is a different place than when your client left all those years ago, but you still want to make sure you're arguing past persecution, because that, even though it would not open the door now, or it would be rebuttable based off of how time has changed, you still have still have a pathway to pursue humanitarian asylum.
So that said, we wanted to reiterate that there is a very clear framework that you want to go through as you are arguing your humanitarian asylum claim. First, it's don't forget about humanitarian asylum. But second, that comes with ensuring that you preserve those claims by arguing past persecution, looking at well-founded fear, and then going through the humanitarian asylum analysis for both prongs, just not simply for the matter of Chen, the severe past persecution prong, but also for this other serious harm prong. And hopefully the resources that we have provided you will help you make some of those claims, but given that, we want to open it up for questions, and we'll try our best to answer any questions that you may have, knowing that we are, as Alexis mentioned, not attorneys. We're student attorneys working in this space, but we'd love to answer your questions. Yes, thank you.
I'm just wondering, when we review the cases, if you look at domestic violence, and somewhere you talked about like periods of detention, but did you see any sort of case law with the board on domestic violence as severe past persecution?
I have not seen that yet, not as recognized as severe past persecution. I think that would probably using domestic violence as a route to other serious harm and returning to a place where this client was subjected to domestic violence. And however, you can still argue it, depending on the extent of that. So if it was like ongoing torturous mental and physical anguish, I think that's certainly recognized, especially in a lot of countries, in country reports. If you can support that in that country, domestic violence is not prosecuted in the same way that it is in the United States, I don't see why it wouldn't be a route to pursue, but I would imagine it would be, based on current case law, supported more in the other serious harm prong.
And as Alexis kind of alluded to, even if the perpetrator is no longer in the country or would no longer be a perpetrator, if there is this culture where domestic abuse isn't prosecuted or is very prevalent and your client has a greater than 10% chance of suffering it in the future, it would make a strong case, I believe, but haven't seen it in the presidential decisions, but for other serious harm. Yes?
Hi, first, thank you very much for your presentation.
Thank you.
I was wondering if I'm looking at your case law examples of other serious harm and noting that, it's like can't find medical care, there's pollution. So that would never be viewed as persecution if you just did a past persecution analysis, yet knowing that LS says that it's the same severity of harm. So I'm wondering if we can kind of go backwards and use some of the case law under the other serious harm prong to widen our past persecution argument to say, well, you're saying severity of the harm equals pollution. Absolutely, 2 weeks in custody is going to equal past persecution, and other serious harm, vice versa. So I know that.
I think that that is a really interesting argument and an interesting analysis. I have not seen it in any of the case law. And again, I'll repeat it for the recording and for everyone else in the room. The question was looking at the decisions and the types of other serious harm in the case law, so the harm that has been considered other serious harm, and then also knowing that other serious harm must be persecution in the aggregate. Could you make a backwards argument to say if XYZ harm has been considered to be persecution as part of other serious harm, could that broaden the scope for persecution in specifically the Eighth Circuit, but in other, which is very narrow, but in other circuits as well. And again, I have not seen that done, but I think that it's an interesting argument as you're looking at total persecution, where you're basically saying that because this would be considered persecution in one circumstance, it should be considered persecution in another circumstance as well. So we have time. One more question. I see the last question in the back. Thank you.
Do you know the success rate for this argument of other serious harm?
It's a relatively recent argument, and so, I mean, relatively recent in terms of immigration arguments, and since it hasn't really been developing since LS. We haven't done a full survey as far as what the success rate has been, and so our hopes in providing those cases would be examples of when it has been successful, but I don't think I have an answer for you on that. I'm sorry.
I'd say the other challenge is that most of the precedential decisions are remanding, so they're strongly suggesting or they're saying that certain things should be considered other serious harm, but they're not reaching the decision because they want the immigration judge to make that final decision, and those decisions aren't published. So I don't know that we can say for certain, even if we had some type of data, what the percentage would be. But I think we are seeing in the circuits, and then again, through matter of LS, that the board is open to these arguments being made, and they would like to see more of these cases, I believe, so that we have more guidance on what should be considered other serious harm. So that being said, thank you again for joining us, especially early in the morning. We hope you learned quite a bit.
Okay, folks, we're going to start with the next session. I'm Steve Miley. I'm the director of the Immigration and Human Rights Clinic, which is one of the 3 clinical programs in the Binger Center for New Americans here at the U of M Law School. I also teach refugee law and immigration law here at the law school. Good to see everybody. Thanks for coming. This second session is going to be on a relatively new topic, a topic that has become more and more important for refugees and asylum seekers in the United States for reasons that our presenters are going to make clear, and that is folks who have traveled to the United States from countries where they've been persecuted and then have decided to try to get to Canada to seek relief from that protection because of their concerns about the climate for refugees and asylum seekers in the United States and how that climate has worsened over the past year or so, as everybody in this room, I'm sure, knows. So a quick word about the Immigration and Human Rights Clinic. We represent asylum seekers, detainees, and victims of human trafficking. And that work has led us to be concerned about this issue of refugees attempting, or in some cases succeeding, getting into Canada and getting status there. We'll talk, and the presenters will talk about that during the presentation. Our presenters are 2 second-year law students here at the law school, Emily Ortlieb and Kelsey Freiberg, and I will turn things over to them now. Thanks very much.
Good morning, I'm Emily and this is Kelsey. And before we get started, we wanted to note that for the purposes of our presentation, asylum seeker and refugee will be used according to the Canadian system. So a refugee is someone who has been given actual refugee status by the Government of Canada or the United Nations High Commissioner for Refugees. Asylum seeker is someone who has applied for refugee status but not yet received it. Generally speaking, a person is an asylum seeker in Canada while they are applying for refugee status, and then becomes a refugee once they are granted refugee status. Asylum seekers are given a conditional order of removal, which is then either revoked if they are awarded refugee status or becomes enforceable if they are denied and exhaust their appeal options. Also, we'll likely be using both terms illegal immigration, specific to the U.S. system, and irregular immigration, specific to the Canadian system. Today, we'd like to provide you with a basic overview of the interaction between the two systems and how the law particularly affects asylum seekers. We'd like to start by briefly setting the scene, mentioning some of the comments that have been made by Canadian and American politicians, and exploring the implications that some of those comments have had on migration patterns of asylum seekers. Next, we'll explain why this is particularly of interest to us in the Immigration and Human Rights Clinic. Then we'll spend most of our time today discussing the Safe Third Country Agreement, officially titled the Agreement between the Government of Canada and the Government of the United States for Cooperation in the Examination of Refugee Status Claims from Nationals of Third Countries. Kind of a mouthful. It's a treaty between the U.S. and Canada which aims to better manage the flow of refugee claimants at the shared land border. We'll discuss what this treaty says, what it means, and the exceptions that may apply. Then we'll go through some hypothetical scenarios.
Cool. So as Emily noted, we wanted to start with some political context and why this was a topic of interest for us. So obviously this controversy is not new, but it is relevant in part because of some executive orders released by President Donald Trump in January of last year. On January 27th of 2017, he issued the Protecting the Nation from Foreign Terrorist Entry into the United States, commonly known as the Muslim ban or the travel ban, along with a few others, which lowered the number of refugees to 50,000, suspended the U.S. refugee admissions program for 120 days, suspended the entry of Syrian refugees indefinitely, and then directed some suspended entry for individuals from 7 primarily Muslim countries. Excuse me. So, just north of the United States, on January 28th, 2017, which was the very next day after those executive orders were released by President Trump, Canadian Prime Minister Justin Trudeau posted this tweet, which was widely celebrated as a direct rebuttal to the executive order. The tweet read, quote, "To those fleeing persecution, terror, and war, Canadians will welcome you regardless of your faith. Hashtag diversity is our strength." So, this political context has had implications on the migration patterns of refugee and asylum seekers. This graph shows the people crossing illegally into Quebec in 2016. So we can see a steady increase leading up to the November election and a major spike after the election. Statistics from Canada Border Services Agency tells us that this trend continued into 2017 with another big jump in January of last year after Trump's travel ban and after the tweet from Justin Trudeau. Advocates are noting that these refugees don't feel safe in the United States. I don't know if anyone here has had any similar situations, that the executive orders like the travel ban have been instilling an enormous amount of fear and insecurity in people, both in Muslim refugees and otherwise. And we want to note, too, that Canadian immigration attorneys right now are reporting that they're receiving calls from people who are originally from Mexico, Central America, South America, and Africa. So it's not just a spike in claimants from Muslim-majority countries. Attorneys are hearing from people who are currently in America and do not feel that they will get a fair hearing. So again, there's been a noticeable increase in these types of calls, and a lot of this people think is stemming from this welcome to Canada sentiment. So what has been happening? Here are some recent headlines. Asylum seekers flocking to Canada. Fearful of Trump's America, asylum seekers from across the globe stream into Canada, and so on. So this sentiment has been a pretty major source of frustration for Canadian immigration officials. Also, there's been some disagreement in the Canadian public over whether these newcomers to Canada are real refugees or truly deserving, etc. So there's been quite a bit of political debate in the Canadian immigration sphere. And again, particularly for Canadian immigration officials, because there are still, of course, specific requirements to be a refugee in Canada, and if you don't meet those requirements, you will be removed just like you would be in the United States. So while for us this is a somewhat refreshing message from Justin Trudeau, and for many immigrant advocates, given the political climate just south of the Canadian border, it is somewhat misleading because misinformed asylum seekers are showing up at the border expecting entry. And we want to note, too, that Justin Trudeau did send a tweet later in August. We assume due to some of the pushback from immigration officials and the Canadian public attempting to clarify the asylum process. His August tweet said, "Canadians can be confident in our immigration system. People who cross the border in an irregular way will not be at an advantage." But a look at the data from Canada, there's been no decrease after the August tweet. So there's been a continued increase through 2017 and into 2018.
So most people have been entering through Quebec, which is likely due to its proximity to New York, and because the majority of those fleeing to Canada have been Haitians that settled on the East Coast and fear loss of protected status. The influx of asylum seekers, which averages about 250 people per day and sometimes 500 people per day, led the Canadian government to set up a border camp, like we see here in these photos, near the New York state border. But Canadian officials are warning would-be refugee claimants that their tales of persecution and requests for asylum do not mean that they will necessarily be accepted into Canada. There's no special protection designation for Haitian immigrants in Canada, and immigration officials said last week that about half of all Haitian citizens who sought asylum in Canada in 2016 were refused. Still, many Haitians continue to seek refuge in Canada. So as previously mentioned, we're both students in the Immigration and Human Rights Clinic here at the law school, and the vast majority of our clients are asylum seekers. Our interest in the fate of those who flee the U.S. to seek refugee protection in Canada is the result of an experience that we had with a client in our clinic over the last year. So last school year, we had a client who had a strong asylum claim here in the U.S. His father was an outspoken critic of al-Shabaab in Somalia who was murdered along with his brother. Our clinic filed his application for asylum, and he was given a hearing date. But then, all of a sudden, he stopped answering phone calls and emails. We finally heard from him this past fall, and he said that he had gone to Canada and received refugee status. This was incredibly relieving to hear, as he had previously been an incredibly responsive client. He and his wife had put their lives in danger to come to the United States in the first place. They had entered through South America, made their way up through Central America, and then into the United States. His wife was also pregnant with their child at the time. We did what we could to assure them repeatedly that we believed in their asylum case, but they still took their lives into their own hands and left for Canada. So this got us interested in what implications are for our clients and led us to the Safe Third Country Agreement. So the STCA, as it's called, is part of the Smart Border Action Plan. Both the U.S. and Canada signed the agreement on December 5th, 2002, and it came into effect at the end of 2004. The STCA is actually part of a 30-point action plan to improve border security and cooperation between Canada and the United States. It was designed as an attempt to help prevent asylum seekers from so-called forum shopping, and is also meant to help both governments better manage access to the refugee system in each country for people crossing the Canada-U.S. land border. The timing is also of interest because the U.S. was still reeling after the 9/11 terrorist attacks in New York, and border security was a heightened concern for both governments. Officials in both countries were concerned about potential new influxes of unknown numbers across unprotected borders, as not all irregular border crossers will notify officials when they arrive in the country. The agreement applies to those making asylum claims at a land border port of entry between the U.S. and Canada. Under the STCA, refugee claimants are required to request refugee protection in the first safe country they arrive in, the U.S. or Canada, unless they qualify for an exception to the agreement, which we'll talk about shortly.
So, as Emily mentioned, this came into effect in 2004, and since then it's been pretty contentious, in Canada in particular. So it's been criticized as not containing a mechanism for meaningful monitoring, which it doesn't have, meaning there's no way to really measure or collect information regarding its effects on individual asylum seekers or refugee claimants. The conservative monitoring provisions that the Act does have more so monitors whether the STCA is being applied based on its terms, and it doesn't really look at how, if correctly applied, it's affecting asylum seekers. But many refugee advocates on both sides of the border in the U.S. and in Canada have outspokenly opposed it for a few reasons. First, right after it was introduced in 2005, a coalition in Canada, it was comprised of Amnesty International Canada, Council for Refugees, and a few other claimants. They challenged the STCA on the grounds that the United States was not a safe third country for asylum seekers, and they cited a few reasons why they felt that the U.S. deviated from international asylum protections, including immigration detention, expedited removal, withholding of removal, statutory bars to asylum, and a few others. And so the argument was essentially that the U.S. failed to meet these requirements and thus could not be considered a safe country for refugees. In 2007, as a result of that filing, the Federal Court of Canada did find that the United States was not a safe third country and did not follow its refugee protections standards under international law. And then later this was overturned in 2007, and it was decided that it was actually overturned on other grounds. And there has been a recent challenge in federal court based on the Canadian Constitution. So while it's a little bit outside the scope of this presentation to talk about, the nuances of what safe third country agreements are, we just wanted to make note that there's been a lot going on in Canada and both in the U.S. with this agreement. Okay, so on this handout that we have, it's the color one in your little binder there. Yes, Emily has it. So the way that we thought about this agreement, it's a very long agreement, we just wanted to break it down to 2 easy steps. So the first step is, does the agreement apply? And then the second step is, if it does apply, could this person or this family fall under one of these exceptions? So we're going to start with that first question. So who does it not apply to? It doesn't apply to U.S. citizens or to habitual residents of the U.S. who are not citizens of any country or stateless persons. And the agreement does apply to those making asylum claims only at a land border port of entry, an official land border port of entry between the U.S. and Canada. It also applies at airports, but only if the person seeking refugee protection in the one country was determined to not be a refugee in the other and is in transit through that country. So if someone lands in the U.S., it applies for asylum here, is denied, and in their deportation stops at a airport somewhere in Canada, the agreement would apply to them, so they can't make a refugee claim in Canada. Yeah, we can have a question, that's fine.
What if somebody has voluntary departure? Is that considered a deportation or not?
I would assume so. We can look, yeah, I would say we can look into that. Also, at the bottom of the pamphlet that we have, or the sheet, there are 3 websites that have numbers you can call and emails. We've only read about it in the context of a formal deportation, so I'm not sure if someone was, paying their own ticket and doing the voluntary departure route, if it would apply. And we'll get into a little bit the nuances of why it is that once you're already in Canada, you can make a claim. It's just the agreement applies to you when you show up at an official border point of entry. And the airports, as far as we know, only applies with deportation, unless Emily's seen something else.
Yeah, no.
But I wouldn't speak conclusively on that because we haven't seen anything with voluntary departure, but that is a good question. So Emily is going to get into the nuance of a little bit of what you were talking about, not so much about the airport, but about what this whole official land border point of entry verbiage means.
Right, so theoretically, a person who arrives in the U.S. and applies for asylum here is technically barred from also applying for refugee status in Canada. But there is an implied caveat. The agreement does not apply to those who are already in Canada when they make the claim, as it only applies to those making claims at a land border port of entry. This is why hundreds of families are entering at unofficial border crossings. For example, many who cross in rural upstate New York go down a road called Roxham Road into Quebec. Others are crossing at a small town in Washington State, and still others are crossing in northern Minnesota. When a person is approached by the Royal Canadian Mounted Police, they're warned, stop, this is an illegal crossing. If you cross here, you will be arrested. Asylum seekers choose Roxham Road and other unofficial crossing routes because the Safe Third Country Agreement bars them from entry if they make an asylum claim at an official border point. If an asylum seeker gets into Canada through an unofficial crossing, they are not subject to the agreement. So, upon crossing the border, these asylum seekers are arrested, searched, and given a background check. They have 2 weeks after arriving to make a claim, as opposed to a year that they have here in the United States. Once they request to be admitted to Canada as refugees, they have immediate access to legal aid and social assistance before they get a hearing, unlike in the U.S. They receive a date to appear before a refugee tribunal, which by law cannot be more than 2 months away. Also, unlike in the U.S., they don't have to wait in detention centers for the court date to come. There is, however, a significant backlog currently, which includes about 40,000 pending cases in the Canadian system. Claimants are now expected to wait about 17 months for an asylum hearing. If someone is put into detention when crossing, they have the right to appear before a judge within 24 hours. They also have a right to remain in Canada while the Immigration and Refugee Board decide their case, a process which, like in the U.S., can take years. Many border officials in Canada feel that the STCA is not functional, mainly in that guarding irregular border crossings is straining resources. One official said, if the government wants to have a grip of the refugee flow, they should suspend the agreement and have people come through the regular port of entry. This has not happened, and Trudeau nor the Minister of Immigration and Refugees has commented.
We want to note, too, some of the consequences that the Canadian immigration and civil rights groups have been raising about these border crossings, namely the dangers that are involved, particularly this time of year. So with increasing numbers of refugee and asylum seekers crossing at unofficial border points, there are news stories of people receiving amputations due to frostbite. There was a woman from Ghana just a few weeks ago who was found in northern Minnesota. She had passed away due to the hypothermia that had set in. There were a group of men from Ghana who had several fingers amputated, and when asked at the hospital what they were doing, they had said, we're trying to get into Canada. We heard the agreement doesn't apply if we cross at this point. Our visa's expired, and we fear the Trump presidency. And again, this concern has really been intensifying lately, but these pleas continue to be met with silence, both by the Trump administration and by the Trudeau administration, and the only real legitimate challenge to the agreement to date is the constitutional challenge that was filed recently in Canada. So, while we're about to chip away at the agreement with a lot of exceptions, and we just went over the official-unofficial border crossing nuance, we want to highlight the importance of the agreement and the fact that since its enactment in 2004, there have been people that have showed up to Canada expecting entry and have been turned around back to the U.S. and vice versa. So while these are the most recent numbers that we could find, just because there was a study that was done immediately after the agreement passed in 2004, so you can see a steady increase in the number of refugee claimants that were rejected due to this agreement. And these are the numbers of people that were showing up at official border ports of entry that didn't qualify for an exception. The agreement applied to them and they were turned around. But these numbers really only in part tell kind of half of the story, because what's been happening, as Emily said, is that people are coming, they're just not coming through formal border ports of entry. So statistics show a striking decline. I don't know if you guys can see these numbers. Show a striking decline in asylum claims made at official border ports of entry after the STCA came into effect. So what does this mean? Well, many say that the agreement, and these numbers demonstrate that the agreement is incentivizing illegal and likely dangerous border crossings across the U.S.-Canadian border. And insofar as the agreement creates substantial barriers for asylum seekers to gain entry at the original official border port of entry, it incentivizes illegal entry or irregular entry. Additionally, this means that many more migrants are reporting that they are turning to smugglers, putting them at an increased risk for exploitation. After crossing, the process of getting admitted permanently to Canada, too, is uncertain, but people keep crossing illegally because while they wait for refugee status in Canada, at least they're safe.
Okay, so the second step here is determining whether an exception applies. The second part of the application of the STCA involves 4 exceptions that consider the importance of family unity as well as the best interests of children and the public. So you can see there's 4 exceptions: family member, unaccompanied minor, document holder, and public interest exceptions. So even if someone qualifies for one of these exceptions, refugee claimants must still meet all other eligibility criteria under Canada's immigration legislation. For example, if a person seeking refugee protection has been found inadmissible in Canada on grounds of security, for violating human or international human rights law, or for serious criminality, that person will not be eligible to make a refugee claim. Also, by qualifying for an exception to the Safe Third Country Agreement, the person is not automatically accepted as protected or automatically granted refugee status. He or she merely has the opportunity to apply for protection in Canada rather than in the United States. Then the person must go through the same procedure as everyone else. Falling under an exception just means that you won't be turned around and immediately denied entry. So going back to the first exception, we have the family member exception, and refugee claimants may qualify under this category of exceptions if they have a family member who is any one of the things that you see listed here. So a Canadian citizen, permanent resident, a protected person, has had an order of removal that's been stayed on humanitarian or compassionate grounds, holds any kind of valid Canadian permit, or has made a claim for refugee status in Canada and has been accepted by the Immigration and Refugee Board of Canada. A very important area to look at as well is that family members are a little different under this agreement than what you might think under traditional family classes. In that, the class itself is relatively broad and includes a large number of family members beyond nuclear family members. So here we have spouse, legal guardian, child, parent, sibling, grandparent, grandchild, aunt or uncle, nephew, niece, common law partner, and even same-sex spouse. So if you have someone who lands in the United States, has a nephew in Canada who's studying at the University of Queens, and has a valid Canadian study permit, that person can apply for protected status and fall under this family member exception. There's 2 things that we'd like to bring to your attention. First, that cousins are not eligible to be relatives under this exception. And second, half-siblings are considered the same as full siblings. Therefore, a half-brother or half-sister can be a qualifying relative. An aunt or an uncle who is a half-brother or half-sister of a parent can also be a qualifying relative.
So of the 4 exceptions that we're going to go through, family member exceptions are by far the most used and most utilized exception. To trigger this exception, the burden is on the asylum seeker to demonstrate to the Canadian border official that they have a qualifying family member in Canada, and to demonstrate that there is truly that familial connection. How this is playing out in practice is something we wanted to run through quickly, because when the STCA was first implemented, Canadian border officials stated that they would take a generous and liberal approach to the family member exception, and would not insist on original identity documents and original proof of familial relationships. But generally speaking, several scholars and advocates have criticized the STCA's exceptions for these reasons, particularly the family member exceptions, as being applied inconsistently and inflexibly, raising concerns then that asylum seekers who would fall under one of these exceptions are actually being turned around. Practitioners have criticized, saying it feels entirely subjective, that it just depends on what border official you get out on what day, and vice versa too, coming back into the United States. So it's argued again that they're inconsistent and inflexible evaluation standards. But there appears to be a growing insistence on original documentation, and this is coming from several news articles and law review articles where immigration attorneys are explaining this. One Canadian immigration attorney says, the Canadians are really big on documents. They like to see an original birth certificate and an original photo ID or passport or a country ID from the individual coming into Canada, and they'll accept copies of documents from the relative in Canada. We are very insistent on documents because in our experience, the Canadians are insistent on it. The better the documents, the better your chances are of getting in. Naturally, this emphasis on original documentation can erect some pretty significant hurdles for asylum seekers, people who are fleeing. I mean, oftentimes this is, a very calculated decision, but sometimes they may not have original documentation. They may be fleeing from a place where they don't have access to original documentation, so this has been a source of controversy. But everything that we're seeing and we're hearing is that original documentation is going to be really important. And actually, there was one case we read where an asylum seeker who had documentation and had testimony supporting this family relationship was asked to provide a DNA sample at the border. And, it matched, and so thankfully they at least went through that step, and he was let in rather than just saying, we don't believe these documents. Another thing practitioners have been noting is that people are sometimes being turned away, even with documentation, if they feel that the person is not particularly close to the relative. Again, that's nowhere in the STCA, but that verbal testimony of, how often you're communicating with this family member, how well you know this family member, when the last time you saw them, those are some of the questions that border officials might be asking. So just keeping in mind that, well, in theory, someone can show up at the border and say, I have a family member in this area, and they may fall under the exception. They may still be turned away based on these. Yeah, we have a question.
Yeah, I have a question. What have you seen about undocumented parents in the U.S. having U.S. citizen children crossing the border and asking for asylum because the agreement doesn't apply to U.S. citizen children, U.S. citizens. So if they are minors, crossing the border with their parents, with a Canadian official allow them in to seek asylum?
Sure. So the question, correct me if I'm wrong, was essentially if you have a U.S. citizen parent, and in the hypo are the children U.S. citizens as well then, I assume?
No.
Two undocumented parents. Okay, so the question is we have undocumented parents and U.S. citizen children. So Emily can jump in as well, but actually the numbers, which we'll get to at the end, of asylum being granted in Canada is exceptionally high in comparison to the U.S., but for U.S. citizens, it's exceptionally low. And we'll get to the undocumented minor exception in a little bit, but I'm pretty sure they're excluded under that as well. You can...
Yeah, so they are excluded, and I haven't seen a lot of that, but what I have seen is typically the parents will go by themselves first and bring the children over later. But again, we haven't seen that very much.
It's also, the question also you're asking is about the exception. So if they, because we're at the stage of exception, we're assuming they showed up at an official land border port of entry and are asking to get in, and the agreement, in theory, doesn't apply at all to U.S. citizens, so they would be turned around unless they qualified under another exception. However, if they entered at an unofficial border crossing or in some other way made the claim while they were in Canada, that would be different, but it does exclude U.S. citizens. Okay, so the second exception is the document holder exception. So while the first one, the family member exception was looking at if you had a family member who had any of those things, a work permit, study permit, etc. This exception is if the asylum seeker themselves have one of these documents. So if they hold a valid Canadian visa, a work or study permit, a travel document, if they're not required to get a temporary resident visa to enter Canada, but require a U.S. issued visa to enter the U.S.
Then we have the third exception for unaccompanied minors. And refugee claimants may qualify under this category if they are minors, so like in the U.S., under the age of 18, who are not accompanied by a parent or legal guardian, who have neither a spouse nor a common law partner, and do not have a parent or guardian located in Canada or in the United States. And if the minor does have a parent or guardian in Canada, then he or she is able to use the family member exception instead. And the final exception is the public interest exception. And refugee claimants may qualify under this exception if they have been charged with or convicted of an offense that would subject them to the death penalty in the U.S. or in a third country. In certain cases, if the deportation of a person would subject him or her to serious harm, then this exception also applies. However, a refugee claimant is ineligible, as I mentioned before, if the person is found inadmissible in Canada on the grounds of security, serious criminality, violation of international law, or found to be a danger to the public.
So now that we've run through the first question of does the agreement apply, and we've run through the second question or step in the analysis of does one of the four exceptions apply, or when would those apply, how do those play out in practice, we wanted to run through two hypotheticals at the end. So let's say that we have a client, Iralia. She's currently here in the United States. She was born in Jamaica and came here from Jamaica. She was male at birth, but has since transitioned so that her external gender presentation better aligns with her internal gender identity. She traveled through Central America, through Mexico, and enters without inspection at the U.S.-Mexico border. Let's say she's been here for 7 months. She settles in Queens, New York, and after Trump is elected and after Trudeau's tweet, she decides to flee to Canada after being in the U.S. for 7 months. She's talked it over with friends and family. She has family back in Jamaica that have said, oh, I've heard all of these horrible things, yada, yada, yada. We all think you should go to Canada. So let's say she's not represented. She makes this decision. She has not yet filed for asylum and makes the decision to go to Canada. So she's made the decision. She wants to leave. What are some of her options, and what are some of the barriers that are going to come up? So the first question is, does the agreement apply to her? From what we know, she's not a U.S. citizen, which would exclude her, because presumably she's a citizen of Jamaica. From what we know, she's not a stateless person, but we would want to know where she's crossing, because, as we mentioned, that is going to be pretty indicative of whether the agreement, will be indicative of whether the agreement is going to apply to her or not. If she enters at an official border crossing, she will need to fall under one of the four exceptions, or she will be turned around to the United States. And if she enters at an unofficial border crossing and she makes it into Canada, she will have to make an asylum claim, as Emily mentioned, within the first 2 weeks. Sure.
Could she just fly into Toronto and enter that way? Because she's not subject to deportation. Would she be not subject to the agreement under those circumstances?
I suppose, yeah, she could. I mean, the airport, the agreement only applies at the airport if you're coming through like you said, the deportation route. So theoretically, I suppose she could. We haven't read any articles or anything of that happening, surprisingly. What a lot of people are doing is taking taxis across and walking across, so I'm not sure. Yeah. Oh, I'm sorry, I'm supposed to repeat the question in here. The question was if someone could fly in so as to evade the agreement if they're not in deportation proceedings. So again, much of this will hinge on where she enters on that border. And then does an exception apply? So there wasn't a ton in the facts here, and we could have added it, but we thought it was somewhat straightforward of, if she has a family member, that's that pretty broad category of anyone in Canada. If she's under the age of 18 and without a guardian, either in the U.S. or in Canada, if she has a Canadian visa, study, work document, or if she's facing the death penalty, which is a pretty narrow public interest exception. It sounds very broad, but it's very, very narrow. So again, if none of these exceptions apply to her, she could try to get in through the visa waiver program and try to take that route, and we'll touch on that at the end of some legal ways to get into Canada. But if none of these exceptions apply, so much of what happens with Aurelia is going to hinge on where she enters on that border. Quick variation on the hypo. A question a lot of people have is, what if she applied for asylum in the United States and was denied and then made the decision to go? So if she's in removal proceedings and is being actively deported, like we've discussed, and ends up at an airport, the agreement does apply. What we've seen in some cases and some stories is that while this might seem somewhat antithetical to this safe third country agreement, some refugees, actually several refugees, have been able to apply for asylum and be granted an asylum after having been denied in the U.S. Theoretically, they're both meant to be similar asylum. Some, gender claims are a little bit easier in Canada, etc. So while someone denied in the U.S. might not have as strong of a chance at being granted asylum in Canada, it doesn't per se affect the agreement in any way. You would still go through all of the same questions of where did they enter, are they a U.S. citizen, do any of the exceptions apply? So in sum, having applied for asylum in the U.S. and having been denied doesn't inhibit her from making a claim in Canada for asylum or for refugee status, if she's already on Canadian soil. The agreement doesn't necessarily preclude that.
Our second hypothetical concerns Duriel, who entered the United States on a 6-month tourist visa and currently lives with his sister, who has lawful permanent resident status based on a diversity lottery visa. The political climate in his home country has recently worsened. His father and brother were both murdered, and he retains you to assist him with his asylum application. Just after it's filed, he stops responding to emails and phone calls, and you hear from him eventually, and he tells you that he's currently in Canada but was denied refugee status and is looking to come back to the U.S. So some questions here. What is, first, the status of Duriel's U.S. asylum application? So his U.S. application was considered abandoned when he went to Canada because he did not notify the U.S. government to obtain advance parole. And because each person is only given one opportunity to file, he will unfortunately not be able to refile. So then suppose that he did not initially apply for asylum, but is now back in the U.S. and wishes to apply. Can he do that? Theoretically, he can. Asylum is available to anyone entering the U.S. as long as he applies within a year of arriving. However, the U.S. could also deny his claim just as Canada denied his refugee claim. So here are some of the numbers. Canada has increased deportations of would-be refugees this year already. And this spike in deportations comes as Canada faces a record number of migrants and is on track to have the most refugee claims in a decade. This has left the country scrambling to cope with the influx of asylum seekers. Between January 2014 and September 2017, Canada sent 249 people to 11 countries for which the government had suspended or deferred deportations because of dangers to civilians, including Iraq, the DRC, and Afghanistan. Notably, new data also shows that asylum seekers are obtaining refugee status in Canada at higher rates as fears increase under the Trump administration. Many of these people crossing into Canada may find hope since Canada's acceptance rate is considerably high. 2017 statistics released by the Immigration and Refugee Board of Canada found that almost 70% of claimants were granted asylum, which is up from 63% in 2016. For comparison, the grant rate in the U.S. for last year was about 40%. Some types of asylum claims might also be better in Canada, as Kelsey mentioned, and others in the U.S. Both countries generally use the same United Nations-based standards for asylum, which are fear of persecution based on your race, religion, nationality, political opinion, or membership in a particular social group. But each country may look at certain types of claims slightly differently. Claims based on gender, for example, tend to fare better in Canada. Again, there are pros to seeking refugee status in Canada. As you get a legal aid assigned lawyer, you're not put in immigration detention, and you can make long-distance calls to gather evidence that your lawyer tells you is needed.
So we briefly touched on the visa waiver program. We're obviously not going to go into that. We just wanted to highlight that. We don't expect you to be able to see the photo on the right, but it's that link on the bottom of the page that we handed out. It's canadavisa.com, and this is just a screenshot of it on our laptop. So if you see this page, you are at the right place. That was suggested by the Canadian Minister of Immigration, Refugees, and Citizenship, who gave a speech here at the Humphrey School at the University of Minnesota back in December. And his advice was that the best way to go about getting into Canada or entering Canada from the United States is to apply through their visa program. That way you're in Canada, you're on Canadian soil, and if you feel you have a valid claim for refugee status, you can make the claim at that time. There are a variety of programs, including federal skilled worker programs, express entry, and so on. As we wrap this up, we just want to highlight again the importance of the agreement and the very real possibility that it could result in deportation back to the country of origin, regardless of what is being tweeted and spread on the internet, as that is what a lot of people who are crossing are basing this welcome to Canada sentiment on. Entering Canada irregularly or illegally is very risky for a variety of reasons, as we've highlighted, especially in late January or early February. As mentioned, there are reports of asylum seekers who have passed away, who have suffered extreme frostbite and hypothermia. And finally, if their asylum claim is denied, they will be deported from Canada and they will be unable to file for asylum in the United States. So there are very real risks. So we have like 7 minutes left. We know lunch is at 11:45. We are equally excited for lunch. So we will try to stick to 11:45, and I know we answered a few questions. Did anybody have anything additional that they were thinking of? Yeah.
Are there other countries that the U.S. has a safe third country agreement with, do you know?
No, there aren't. And basically, the gist of this agreement comes out of the fact. Oh, right. Are there other agreements that the U.S. has similar to the Safe Third Country Agreement with other countries? And so the U.S. and Canada border is, I believe, the longest unprotected border in the world, and that's kind of why this agreement came to be, was to better protect it. Does that answer your question?
Yes.
Okay, thanks.
Yeah.
I have a hypothetical. If there's a pending asylum family from El Salvador with the typical El Salvador sort of claim with a mother and children who are here and have applied for asylum, and it's pending, and the father of the family, who's not married to the mother, has already been deported, who applied for asylum and was denied, and would like to reunite with the mother and the children, but is now down in Central America. It seems like the strategy of this family would tend towards wanting to reunite in Canada, because even if the father tried to come back to the United States, the father's life in the United States is very tenuous. Can I just throw that out there as a reason for a family to consider going to Canada?
Sure, and I've actually seen this in practice with a family from Romania, actually, that I worked with prior to law school, and that's exactly what they did, and as far as I know, they're still in Canada.
And also, if the mother and the children abandoned their pending asylum in the United States and took it up in Canada, they would then be able to have a family unity claim for the father to travel from Central America to Canada to reunite with them.
That's correct, yeah.
In a safe way, without the rigors of the horror of trying to travel with the smuggler and so on.
Exactly, yes. Thank you.
On the assumption that they're accepted.
I'm just going to ask, like, this is outside of this agreement, but speaking of family unity claims, we have a lot of U.S. citizens, like where one spouse is being deported.
Mm-hmm.
Do you know anything about the success of family unity claims moving to Canada and things like that? Because we're seeing a lot of separations where there might be some family members that are U.S. citizens and some family members that are now being deported. Maybe not even for criminal reasons, which might be a bar in Canada, but.
Mm-hmm.
Right, so the question is whether there's any hard numbers on the success of family unity claims in Canada. And as far as I know, that's pretty recent in the last year that that's become very relevant, or at least being talked about. And I haven't seen any studies or any hard numbers. Sure. Well, there should be one or two websites on the bottom of your handout where, like an association of Canadian lawyers would maybe be better able to answer that question than we are.
And here, sorry, real quick. And this is just one of the websites, but it's really helpful. Like, we took this test and saw if we could move to Canada. And so you can go through and be this hypothetical family and ask these types of questions of, what's the family-based immigration situation in Canada. So, yeah, question in the back.
Okay, given that for purposes of regular immigration to Canada, even when the breadwinner has a long-term contract teaching at a university, their children with disabilities have been denied permanent entry into Canada, and given how many, for example, Somali kids are being diagnosed with, for example, autism spectrum disorder, how advocacy in the disability community, and I know that this has been a problem even when you're not talking asylum, and as you watch, people from some third world countries coming here, and their kids subsequently being diagnosed on the spectrum, which is a whole other issue. How does that play in with the whole picture? Because that is part of the issue. Any ideas?
Sure. So the question was in reference specifically to if a family is trying, I assume, to cross from the U.S. to Canada or vice versa, and the child has a disability like autism or is somewhere on the spectrum and is denied. Well, I mean, it would depend, I guess, if they were denied in the U.S., they theoretically could still make...
They were born in the U.S.
So they're U.S. citizens?
It's a child who's born in the U.S., and this is what that fact pattern usually is. But given that Canada has denied permanent status to children of people who aren't seeking asylum, they're just looking to immigrate. I'm just wondering where this comes in that whole thing.
Sure. So, I mean, we didn't look specifically into disability, but I would say the Canadian Visa Waiver Program, the Canadian Council for Refugees, CCR, and the Canadian Association of Refugee Lawyers, Carl, are going to be far better versed in what types of things are available. It sounds like you know a lot about the American system and U.S. citizen children who have disabilities like that. So I don't know if they fare better.
I also know a lot about people who are trying to move from other countries.
Sure.
And this has been a real big issue in the disability community internationally. That Canada is saying, yep, everybody except the person with the label can come.
Sure. Yeah, I mean, if you want, we can talk about it down here, too. Again, it's kind of things all I can do is point you to these few websites, but I totally appreciate the sentiment and the passion. Yeah, we'll do one more quick question.
So I'm interested in your comments, and this is probably a follow-up to that last question. We keep hearing El Presidente telling us that Canada and Australia have merit-based immigration systems. What do you think of when you hear that, having the knowledge that you have with regard to the Canadian situation?
Sure. So I think so the question is what we think about, what we think of when we hear 45 talk about the merit-based visa system. And I think a lot of that depends on the framing of it. Because basically when you go to this website, it's a point system. You're given points for your education and your background, and then they basically lay out your options for you as far as visa programs to get you into Canada. And another thing to consider is the Canadian immigration system, even though it is currently more burdened than it has been in the past, is still significantly underburdened than ours is. So that's also something to think about.
All right, cool. Thank you so much for coming. Lunchtime. Thank you.
All right, welcome back, everyone. I hope that you all enjoyed your lunch, maybe an ALP treat as well, and are feeling re-energized. As a reminder to all of you, please don't forget to fill out the evaluation form so that our students can learn from their experience here today. We now have the opportunity to hear from Bess Bover and Julia Wolf. Bess and Julia are both 2L students in the Federal Immigration Litigation Clinic, where they work to make systemic change in immigration law. Today they will be discussing bond hearings, starting with the basics and then moving into advanced arguments about the burden of proof and ability to pay. So please join me in welcoming Bess and Julia.
Hi everybody, welcome. So as Kirsten mentioned, I'm Bess and this is Julia. We are both 2Ls in the Federal Immigration Litigation Clinic. And you might notice that bond hearings are not in federal courts. They are administrative. So the goal of today is to both walk through bond proceedings at a very basic level, sort of go over some strategies and procedure and timelines, things like that. So if you are in the circumstance to be doing a bond hearing, you'll feel more prepared. And then also to get into some of the novel arguments a little bit later on that we've been working on in our clinic, in case you do wind up in federal courts through various means that we'll discuss a little bit later. How many of you have engaged with bond hearings before or are familiar with them generally? Awesome. So it is great that we're going to be going over both levels. So hopefully everyone will be able to get something out of this.
All right, so first we'll be talking about the nuts and bolts of bond hearings. We'll look at when they occur and the timeline of removal proceedings, what they consist of, the legal standards governing bond, and how you can effectively advocate for your clients to get them a bond. You'll see how the considerable discretion that immigration judges have can keep a lot of people in jail, and why being in jail makes fighting their case on the merits so much harder. We'll also discuss what options are available if bond is denied, both options within the agency and in federal court. And finally, we'll introduce, as Beth said, a couple advanced topics related to bond, that the burden of proof should be on the government, not the respondent, and that immigration judges should be required to take into account the non-citizen's ability to pay when setting bond. So we'll explain these novel legal arguments that can be raised in habeas petitions especially, with the ultimate goal of changing the law governing bond proceedings. So this is an area our clinic is particularly interested in as we focus on federal impact litigation to make positive changes in immigration law.
So that reminds me, we did give you a handout that we prepared, an outline of these burden of proof arguments specifically, and we'll get into that a little bit later. But first we're going to go over the very basics. So that will be a resource for you a little bit later on. So first of all, okay, what is a bond hearing? When does it happen? All of that jazz, because it is different from bail proceedings. So in criminal court, you are more likely to get bail pre-trial, whereas in immigration court, although the function of bond is the same, to ensure that somebody will come back and go through their case, there is a very low chance that they will be granted bond, less and less so. It used to be a different circumstance, but in the last couple of years, couple of decades, the assumption has changed a little bit. Also, bond and master calendar hearings are separate. So a person will have a distinct bond hearing, and that will just be to determine whether or not they are eligible to be released and whether or not they should be granted bond to get out of detention. And then maybe simultaneously to that, they'll be going through the merits hearings on their immigration case for their removal proceedings. Statutorily, there is a minimum bond amount at $1,500. While you are going through bond proceedings, so if you get a client and their bond hearing is going to be 5 days later, you can request a continuance. And that will likely be granted because there's going to be a lot of legwork leading up to your bond hearing, because you will need to be responsible for demonstrating that your client is eligible for relief. And that brings us to the ultimate goal of showing that your client is not going to pose a danger to the community or anybody, and that they are not going to be a flight risk, that they will return to court.
So how does this all start? And when do bond hearings happen in the first place? So it starts when the non-citizen is arrested by ICE for one of several reasons. There could be a criminal charge or a conviction unrelated to immigration. They could have several charges or no convictions. They might have a recent pending charge or a conviction that they've already served time for. Alternatively, it could be because they failed to maintain their legal status, if they were admitted on a student visa and they were not a student anymore.
Maybe they were not lawfully admitted to begin with, and ICE was tipped off about them. So the government will issue a notice to appear, which will list the charge or charges that allegedly makes this person removable. And this is what officially begins removal proceedings. So when ICE first picks them up, ICE makes a determination of custody, whether to release them on their own recognizance, which doesn't happen often, or maybe they are subject to mandatory detention if they've committed an offense in a certain category of crimes. And the third option is that ICE can detain them on its own discretion, and then in that case, the non-citizen can reserve or waive a custody redetermination hearing, which is the bond hearing in front of the immigration judge. They simply sign their name on a piece of paper when they are reserving or waiving this right. So the bond hearing, which is a custody redetermination hearing, is in front of the immigration judge and is just to decide whether they should be released for the duration of their immigration court proceedings. So if they waive this right, it means that they will not have this chance to be in front of the immigration judge. So this is not about the merits, it's simply about whether they will stay in jail or not.
So this next slide is sort of to give you a visual before we get into how these bond proceedings advance, just to give you an idea of how lengthy the process can be, how cumbersome. So let's say that your client is picked up by ICE, just as Julia described, and then their bond hearing is set for about a month later, or maybe even later. And in the meantime, they might have their merits hearing first, and possibly simultaneously, you'll be dealing with your client going through criminal proceedings on a pending charge. And so it's going to be very complicated trying to coordinate with public defenders. In the meantime, they will possibly have a warrant issued because they didn't show up for their criminal proceedings because, of course, they were in ICE detention. You will hopefully meet your client in advance of the bond proceedings, and then even if you get a continuance and you are able to do all of this work in advance, your bond might be denied. And so a month later, if your client wishes to appeal, that is when you need to file a notice to appeal with the Board of Immigration Appeals. And that needs to state with some specificity how you feel that the immigration judge erred in making their decision. Not until another month later, perhaps, 3 or 4 weeks, the Board of Immigration Appeals will issue a briefing schedule. So, okay, we're already 4 months along in this process. About a month later, you will file the brief, the government will file the brief, and 4 to 6 weeks later, you will get a decision. So it's going to be about 6 months, which is wild considering that this person in the meantime is just sitting in detention whether they deserve to be or not based on this discretionary decision. So just keep that in mind as we're going through this. It's a lot.
So how will the immigration judge reach their decision to grant or deny bond? This is legal standard to keep in mind as you strategize and prepare for the bond hearing. So first, the burden of proof is on your client, not the government, to prove 2 things: that they are not a danger to the community and that they are not a flight risk. If an immigration judge decides the person meets both of these factors and should get a bond, she is not required to take into account their ability to pay when setting the bond amount. A judge first will make a decision, or should make a decision, about dangerousness, because if they find that your client is a danger to the community, they are supposed to deny bond, even if the person isn't a flight risk at all. And if they make a finding that your client is not dangerous but poses some flight risk, then they might set a higher bond, just like in the criminal context, to guarantee that the person shows up at later hearings so they don't forfeit their bond. So this standard is actually not in a statute or regulation, but was set out in the case Matter of Guerra by the BIA in the 90s.
So the factors that the judge is going to consider in determining whether or not your client is dangerous are several. So these are the things you're going to want to emphasize at your bond hearing. They will consider how long your client has been in the United States, whether or not they've had a permanent address locally, and how they've been integrated into that community, any family ties they have. If they happen to be married and have children, that's going to work in their favor. How they have had an employment history, how steady that has been, what type of work that has involved, and then their criminal history, which is a sort of complicated thing because in immigration court, they will consider just arrests and pending charges and things like that. So you are going to want to show, hopefully, that your client has not committed offenses for some lengthy period of time, or that the offenses weren't severe, because those are all going to be taken into consideration. They also might just be inclined to say, I don't think your client has a form of relief available anyway, so why does this matter? It's highly discretionary, as we've been saying.
So a recent case, just from a couple weeks ago, illustrates the discretion that an immigration judge has, but also maybe clarifies or changes the standard slightly. So the respondent here was a Lithuanian man who had been admitted in 2000 lawfully, but he overstayed his visa. He did have a lawful permanent resident wife and a U.S. citizen child, so there was potential for relief through them. He did have DUI convictions from about a decade ago, and then he had one more in 2017 with nothing in between. And he had also been through AA treatment and that kind of thing. So the immigration judge held, the BIA in this decision held that family and community ties do not mitigate dangerousness when considering nature and extensiveness of the criminal record. So even though the person here had strong community ties, that didn't offset the DUI convictions. And it also held that DUIs should be considered by the immigration judges as a significant factor indicating dangerousness. So the bottom line was that this was enough to hold him without bond, and his family and community ties did not mitigate his DUIs. So now this was a precedential decision, so now immigration judges' discretion should conform to this standard, and they're supposed to weigh these factors accordingly. So even if immigration judges were kind of using this standard anyway, maybe unofficially before, this decision will definitely not make it easier for clients to get bond.
Which has sort of been the trend that we have observed. Okay, so you're going through these bond proceedings, and in advance of the hearing, there's a lot of legwork to be done, as I mentioned. So here are the things that you're going to want to gather and prepare for filing with the court. In your packet, you will want to have important information like police reports that might be relevant. Letters of support from the family will help to show equities if you can get sort of these character letters speaking to the importance of this person in the community, maybe even they belong to a church, things like that. Birth certificates of any of their children, health records, and assorted documents. It's also optional, but in my opinion, highly recommended that you write a brief for the judge, and they might not read it before your hearing, but it is a way to preserve arguments that you might not get to make at your hearing. And I'll talk about that a little bit later. But ultimately, when gathering these documents, you'll also want to exercise some discretion because Maybe you don't want to emphasize some of these things on the police reports, and that's a sort of discretionary call you'll have to make.
So you'll also, depending on the circumstances, want to coordinate with your client's family and friends about appearing at the hearing. This can show that your client has strong ties and community support if they're in the courtroom there. But you definitely want to inquire about their legal status first, and if they're undocumented, you should advise them not to come, just to be on the safe side. So the hearing itself will likely be the first time that your client has appeared in immigration court. Like master calendar hearings, bond hearings are not closed hearings, so they are open to the public, and it's very likely that other attorneys will be there and other family members and friends of the other people who are detained who have a bond hearing at that same time as your client, because they'll just go one right after the other. And as Beth mentioned, not everything has to be filed, even if you have it. So you want to think carefully about if there are maybe damning facts in a arrest record that would not shed a good light on your client. You don't have to include it, but of course that doesn't necessarily keep the government from not including it either.
So just be prepared to discuss it. The day of is going to be a whirlwind. A note for what you can do in advance to make your life easier that day is try and communicate with your opposing counsel at ICE, because sometimes, based on learning about this case in advance and knowing about your client's circumstances more so than they would just at the hearing, they will agree to stipulate a bond amount. And maybe they'll have a condition for that, like, we will stipulate this bond if you arrange for them to go into treatment right away, say if they have a DUI. But that would be recommended if you have the opportunity, because the immigration judge will likely defer to your opposing counsel and be more inclined to agree with that. As Julia mentioned, hopefully you will have your client's family and friends or neighbors in court, so communicate with them at some point in advance that you would like to introduce them to the judge, and maybe even they will be asked to stand. So advance notice about that if people are maybe nervous. Also, you will be one of many hearings that day, so you will be scheduled, say, for 1 o'clock, but the order of those hearings might be random. So you come in at 1, and maybe your hearing will be at 2 o'clock. That's something that you have to be prepared for. And because there are so many of these hearings, your hearing might be 10 or 15 minutes. So no matter how many arguments you have prepared, no matter how thoroughly you have outlined exactly what you want to say, you need to be prepared to jump around and respond to rapid-fire questioning, because everything that you are asked and you try to make this explanation, the government is likely going to contest everything you say. So you need to really strategize about how you're going to fit in the most important facts of your case. You need to show all these equities and shine the best light on your client possible. And if you would like to make certain arguments that we mentioned before and preserve them for the record, such as, hey, the government should bear the burden of proof anyway here, right? That would be something that you do not want to say up front, because it will set you up for sort of a more awkward hearing. They probably don't want to hear that this is constitutionally inadequate right as they're starting. So maybe, I'm not speaking from experience or anything. So maybe tuck that in at the end. If you've been denied bond, say, well, for the record, this is why we feel that this is unfair. So that strategy is going to be important as well.
And just another note for those who aren't so familiar with bond hearings is that we mentioned that they're separate from master calendar hearings, but now, at least in Bloomington, they're so separate that they occur on different days. So that's another thing to be aware of in planning if you're representing your client on both the bond hearings and the merits hearings. So what happens if bond is denied? What's notable first about and different about bond hearings compared to a decision on the merits is that at the end of a bond hearing, after the judge issues their decision, you don't get an official oral decision or written decision. The judge simply says that they deny or grant bond after, making a finding of dangerousness. So this is obviously different from when, for example, a judge will deny an application for asylum when they'll issue a written decision or issue an oral decision, or they'll reserve the decision and then you'll get a written decision later. That's different. That doesn't happen in bond. So it's important to, if bond is denied, to ask, the judge will ask you if your client wants to reserve appeal, and you should say yes, because otherwise you would be foreclosed in being able to appeal. Then you want to consult with your client and decide if to actually appeal or not. So a critical consideration in deciding whether to appeal is whether your client has any possibility of relief. If they don't, they will just be wasting their time in jail when they will be ordered removed anyway. And it's important to explain this to them so they can make an informed decision. And it's also important to tell them how long they might be sitting in jail. The appeals process, as Beth kind of alluded to at the beginning, can take months and months and months. And some clients, even if there is potential relief, aren't willing to do that. And so they should, of course, understand that at the beginning. And meanwhile, as they're sitting in jail during the appeals process, the merits case is continuing.
So you have a couple of potential routes once you've been denied bond, if you were denied bond. The direct appeal will happen at the Board of Immigration Appeals. So I mentioned previously when we were going through this timeline that you will file a notice to appeal. And that's going to involve alleging with some specificity why you think that the immigration judge erred in their discretion, or why you think that this was an inadequate hearing for some reason. And from there, you can advance, if you are once again struck down by the BIA, then you can appeal to the Court of Appeals. And we've seen some of these where people were maybe granted bond and the judge didn't consider their ability to pay, which is something we'll discuss a little bit later, and then they have some success at the Court of Appeals because they say, well, the judge should have considered the ability to pay, and they'll remand for that to be taken into account. Another thing that I did forget to mention is that although you won't necessarily be granted, you won't be given a written decision once you are denied bond, upon filing a notice to appeal, you will receive that decision, and that will be really helpful in sort of structuring your briefs from there, because you will have a much clearer idea of why exactly this is happening to you.
So you also have, just like in the merits context, motions to reopen or reconsider, and these can be made directly to the immigration judge or to the BIA, depending on what the situation is. So in a motion to reopen, the immigration judge can consider new facts or evidence that was not previously available or that could not have been discovered earlier. And a motion to reconsider would be to identify an error in fact or law in the immigration judge's or board's decision, and it should be filed when there's a change in law after the decision that you think affects the judge's reasoning, and it should not introduce new evidence. So these are the same motions that apply in the merits context, but they can also be useful in the bond context too if your client was denied bond. So an example might be if the notice to appear is wrong in a really material way as to the eligibility for bond of your client, and the immigration judge relies on that in making their finding that your client is dangerous. But maybe the correct information showing a very minor offense that would maybe not persuade the judge that they were dangerous. Maybe that wasn't available before the bond hearing, despite your best efforts. Then you might want to file a motion to reopen with the immigration judge. And so finally, we have the option for petitioning for habeas corpus in federal district court, challenging your client's wrongful detention. So this is available after you've exhausted administrative remedies, when you've done everything you can before the agency. Then this would be kind of a last resort. You can't, go directly from the immigration judge to federal district court with a habeas petition normally. So first, the client would have to be detained for a very long time, which is usually over 6 months, although there's disagreement about what that exactly means. And then again, they should also have some form of relief available, because the habeas process can take a really long time, even longer than the agency appeals processes.
Definitely will. So I did want to add another note. The errors in these notices to appeal that Julia mentioned, be on the lookout for that, because it is surprising how often that might happen. And it might be minor details, or it might be really material to your case. So be on your toes and fact check those things. So, okay, now that we've gotten through bond proceedings, the nuts and bolts of the basic level, a project that obviously our Federal Immigration Litigation Clinic has been getting into is raising these novel claims in order to hopefully change the law. And we would like to get into both the ability to pay argument that we've mentioned previously, and also the burden of proof allocation, in that it is problematically on the person who is in detention instead of the government. When you want to raise these claims, or even just potentially raise these claims, you need to preserve the arguments at the very basic level. This is why I mentioned that it is helpful to file a brief before the immigration judge, just in case you don't have a chance to make these arguments verbally in your 10-15 minute hearing. That will help you, that will set you up to exhaust administrative remedies, because you will have these arguments documented and you appeal, and that is denied. You need to exhaust all of your possible options in administrative court in order to get to this stage. And that will set you up to have all these arguments on the record for your habeas petition.
So raising these claims will hopefully ultimately change immigration law that governs detention by setting precedent in federal law that would bind the agency. So the goal ultimately, of course, is to keep people out of jail while they're fighting their removal case. So since there's no right to counsel in immigration proceedings, and many detained individuals are unrepresented, these changes can hopefully make a big difference for them and make it easier for them to fight their case, since it's obviously much easier to fight your case out of jail than in jail. And clearly it's hard enough for lawyers sometimes to do this. So this would hopefully make it easier on people who are unrepresented too.
Okay, the argument that we have worked most with, a big one, is the burden of proof allocation. And that's what we have given you an outline of today, so that you can take that with you, because we will not be getting really into the nitty-gritty here. But generally, there are a couple of arguments you can make as to why this burden of proof allocation is erroneous. First, the constitutional argument is just that it is a plain violation of due process. The Supreme Court in Zadvidas v. Davis stressed that any custody hearing in which a non-citizen bears the burden of proof is constitutionally inadequate, right? So that seems like a fairly straightforward argument that hasn't quite caught on yet. This is especially important because non-citizens possess vulnerabilities that most Americans do not. They have fewer constitutional protections, they have fewer resources and community ties. So it's especially important to protect them at this custody hearing context. This deprivation of their liberty should not be imposed without a sort of constitutionally adequate hearing, and there is a balancing test that you will see on your outline. Pretty much that the private interest of them being released is immense, that the risk of them being detained erroneously is very high because they do have such difficulty in gathering these documents, these pieces of evidence for their defense. And additionally, granting this full due process wouldn't burden the government in any significant way. So they would still have the ability to prosecute the case. And those are the balancing factors that you would want to argue.
And so now to get a little more into the weeds, into statutory interpretation and administrative law, there are also very compelling textual arguments for shifting the burden of proof based on the INA and regulations. So first, the INA explicitly places the burden of proof on the non-citizen in a different section, while the section on discretionary bond, which we've been talking about today, is silent on this issue. So if we assume that where Congress has included a provision in some sections but left it out of others, that it was acting intentionally, then the burden should not be on the non-citizen to prove that they are not dangerous in the discretionary bond context. And so this was kind of the standard in place until 1999 when the board issued its decision in matter of Adeniji. So this case looks at the regulation that explicitly places the burden of proof on non-citizens when they are first picked up by ICE agents in the section addressing the authority of, quote, any officer authorized to issue a warrant of arrest, unquote. So this obviously refers to ICE agents and not immigration judges who aren't officers who are authorized to issue warrants of arrest. But the BIA applied this burden allocation to the custody redetermination hearing context, so the bond hearings in front of immigration judges. So the effect of this decision was to effectively erase the presumption in an earlier board decision, matter of Patel, which had established a presumption against detention, and so now this decision kind of flipped that. There's also a strong Chevron argument against Adeniji, since the BIA could be said to have acted arbitrarily and capriciously by applying a regulation to a context where it's clearly not supposed to apply.
And overturned all of this precedent without really any need to. But you'll see more of that nitty-gritty in the outline we provided you, because that's a whole lot of detail. Of course, the practical argument is much more basic. The government is in a better position to prove whether or not somebody is dangerous or going to pose a flight risk, right? Your client, hopefully you have this client, is not entitled to counsel. They are not, a non-citizen is not entitled to counsel at any point in their removal proceedings or bond proceedings. And so imagine a situation in which a person is going to go through these proceedings totally on their own. They don't have contacts outside of detention, and they are solely responsible for somehow convincing the government and the immigration judge that they do not deserve to be in detention. It's, in our opinion, inconceivable, so that's why we're doing this. So that's a really practical argument to sort of inform why we're doing this. And our second argument is about why immigration judges should take into account a non-citizen's ability to pay when they're going to be setting a bond, if they do successfully secure a bond. It has happened that a person is bond eligible, and the judge sets a bond in the tens of thousands of dollars. And not many people can necessarily afford that, at which point they're being detained for no reason other than not having the financial resources. So the constitutional considerations are that, so in the case Bearden v. Georgia in 1987, it was considered to be a due process violation when a person's probation was revoked because they didn't pay certain fines. And when they revoked that probation, they didn't consider why that person couldn't pay those fines. So that was a due process violation. The point of bond, of course, is it must be related to the objective of preventing dangerousness in the community and to ensure that a person will return to their next court proceeding. And so a high financial stake is not necessarily going to ensure that beyond a certain amount. It means that a person has satisfied the government on those fronts. They're not dangerous, they don't pose a flight risk, and the only reason they're going to be in detention is because they're not financially able, whereas others might be. So it's a problem of equal protection because those who are maybe in poverty are not going to receive the process that they deserve. There's also an Eighth Amendment argument, clearly, that bail should serve the purpose of guaranteeing that that person appears in court. And an impossibly high amount doesn't really further that goal. The INA, also, the Immigration and Nationality Act, contemplates in setting this minimum bond amount, it contemplates that people should get out on $1,500, which is much lower than $60,000, which we have seen. Additionally, the text, and this is really important, the text says that other conditions can be considered. This 236A, which is the discretionary bond proceedings, it states that the Attorney General has the discretion to consider other possibilities, so not necessarily monetary alone, but maybe it will be a circumstance in which an ankle bracelet is appropriate, or a person is going to be in sort of a rehab facility. Things like that could definitely ensure that they will be taken care of, they won't pose a danger, they'll return to court. And then the Bail Reform Act is, of course, applying to federal criminal cases, but if you can sort of consider it analogous to these immigration proceedings, pre-trial bail, in pre-trial bail situations, the statute states that courts must consider these alternative conditions, and they can't impose a financial obligation that results in pre-trial detention for no other reason than inability to pay. So we have seen some cases that are going to hopefully be successful on this front.
So one of those, which makes a good example, is Hernandez v. Sessions, which was decided last fall by the Ninth Circuit. This was a preliminary injunction sought by a class of plaintiffs seeking habeas relief on the ground that the immigration judge did not consider their ability to pay when it set their bond amounts. So the facts of the two plaintiffs kind of illustrate the different situations where this issue can come up. The first plaintiff was an elderly Mexican woman who had been in the U.S. for 3 decades, and she had no criminal record. But ICE picked her up at her house when the agents were allegedly looking for suspected gang members. The immigration judge didn't find her to be dangerous, but thought she would be a flight risk. So they set bond at $60,000, which she obviously couldn't pay. The second plaintiff was a young gay man from Honduras who had a very light drug-related criminal record. He told the judge he couldn't pay more than the minimum statutory amount, $1,500, but the judge set bond at $3,000. He was unable to pay, so he ended up staying in jail for 4 years. He had a few subsequent hearings, bond hearings again, to kind of revisit this issue and give him a chance again to get out on bond. But each time the judge didn't change the amount. Both plaintiffs ended up being released eventually because different charities paid their bonds. The Mexican woman's had been lowered by that point to a few $1,000s. But the Ninth Circuit ordered immigration judges through a preliminary injunction to start considering ability to pay when setting bond. And there's another case on this issue, which is also led by the ACLU, which led the Hernandez case. And this one is so recent that it didn't even make it into our presentation. And it also reached this kind of the same result, but not through a preliminary injunction.
Didn't it come out this week?
Yeah, we heard about it yesterday.
Yeah.
So a district court in the Second Circuit reached the same conclusion. So hopefully these cases signal a positive trend on this particular issue.
What was the name of the one from yesterday?
What was the name of it?
Didn't you write it down?
It was I think a hyphenated name.
What?
Was that it? Yeah, that was it. Yeah. Yeah, thank you.
So it seems hopefully like this is going to be good news on the ability to pay front. It's sort of a very compassionate issue, right? It seems like this could easily be aligned with criminal court proceedings because it is so obvious that nobody, in our opinion, that nobody should be held in jail for the mere reason that they don't have financial resources. And then the reason we have given you these outlines about the burden of proof arguments is because this is an issue that is being pushed in a number of places, and we would love to see someday, if you happen to be representing somebody through a bond proceeding, and they do agree to advance into the habeas stage, if they're really committed to staying in the United States and fighting this out. We wanted you to have this resource because these arguments have been made across the country by different clinical groups and things like that, and so hopefully you won't have to reinvent the wheel, and this will get you started on that process. So in conclusion, really, we wanted to give you a basic overview of what bond proceedings entail, and then once you get beyond that stage, these are the advanced arguments that you may or may not want to make, but I hope that you all feel equipped to do this in the future if you find yourself in that circumstance.
So any questions?
We have about 15 minutes, so we'd love to talk about it.
Yeah.
I have a very basic question as a non-attorney. If a judge grants a bond and the government reserves appeal, does the person have to stay in custody, or can they pay bond and the appeal plays out while they're out?
I'll repeat the question. The question was if the judge grants bond and the government appeals, whether the person can get out while that appeal is going. I believe that they don't, that they have to wait. Sorry.
Sometimes they can if there's changed circumstances and you can make a new motion and argue for bond.
Stacy, this is our clinical instructor, Stacy.
Can you say that again? Because I asked the question, but I couldn't hear the answer.
Depending on this, I don't know if Stacy, but it depends. You should be able to pay the bond, yes, unless the government seeks a stay of finding the bond. Like the 24 hours, if the bond was originally no bond or over 10,000, and if they don't do that automatic stay, then you can do the request for reconsideration and could be released if the judge grants it.
I'll repeat that. So they can get out unless the government seeks a stay, and there are some limitations on seeking that stay. So it depends.
But if they do bond out, they might be requested to go back upon that appeal, the outcome of the appeal. So, yep.
In your explanation earlier, for the appeal process, I understood you said you can bring new evidence, but in most other admin law or immigration law appeals, new evidence is usually not allowed by the same client, by the same lawyer. So unless there is like a poor application, counsel earlier, or other extraordinary circumstances, new evidence usually is not allowed. So that's my
Yeah, the question was about usually new evidence is not allowed in these administrative appeals, and that's true, except with the exceptions of if the evidence was not available before and now it is. For example, we mentioned if the information on the notice to appear document is incorrect and there was no way to get that information before the bond hearing for whatever reason, that could be a case.
And that's going to be a motion to reconsider, to clarify, right?
Yes.
So in our circumstance, we did find some totally game-changing information had arrived in our email inboxes 5 minutes into our bond hearing, which would have changed everything. So we filed a motion to reconsider, and we did have success with that. And that's how we got to incorporate new evidence.
Mm-hmm.
It's a lot to digest.
Yes, Stacy?
Exhaustion statutorily required?
The question is whether administrative exhaustion is statutorily required.
This is a pop quiz.
When you're going to file a habeas petition. And the answer is no, it's not. There's also prudential exhaustion, so where you can look at other factors and for various reasons explain why you did not have to, or what you did was enough to exhaust administrative remedies.
Or if they're going to face irreparable harm by having to wait out this administrative decision. If a petition for habeas corpus is going to be the only way that they can have a remedy to their situation, you can make those arguments. Mm-hmm.
Great, thank you.
Thanks, everybody.
Hi, everybody. So my name is Linus Chan, and I teach the Detainee Rights Clinic. And I'm pretty excited to present two of my students, Alicia Granzi and Nicholas Kaler, to talk about motions to reopen. Now, motions to reopen is not a new development, so to speak, in immigration law. However, it is gaining increasing importance. Nick, for instance, has worked on two motions to reopen. One is with the Hamamba class. Those are the class of Iraqis who were recently in Detroit. Their deportation was stopped in order for them to find ways to file motions to reopen. And we also worked on one Somali case which was on the plane, and again, much of the federal litigation is talking about is to get access to file motions to reopen. Obviously, if this topic is of interest and you decide that you want to take on cases, Advocates for Human Rights, again, are looking for volunteers to do motions to reopen for Somalis that are currently detained in Miami. And there are other places where motions to reopen are going to be needed very much so throughout the country. So anyway, I'm very excited that you'll get the chance to hear from them, learn from their wealth of knowledge, and without further ado, thanks.
Thank you, Linus. I'm Alicia Granzi, and this is Nick Kaler, and like he mentioned, we are students in the Detainee Rights Clinic. Thank you very much for being with us here today. Every year, millions of people cross oceans, deserts, rivers, and political borders looking for safety and better opportunities for themselves and their children. While some countries have open borders and some regions have borders so porous it's as if they don't exist, the United States' geography, its infrastructure, and bureaucracy allow it to carefully regulate who is and is not welcome to come and live here, or so Congress would have us believe. Of the 11 million undocumented immigrants in the United States, and for any number of documented immigrants whose status may be affected by crime or a change in diplomatic or political relationships, the ability of the United States government to deport them is an all too real threat to their everyday lives. For many years, the government was unwilling or unable to deport individuals who had been ordered removed from a variety of countries, such as Iraq, Haiti, Cambodia, or Somalia. Citizens of those countries that were ordered removed were released under supervision indefinitely. As a result, many of those accepted these orders of removal because they were told that they were unlikely to ever be removed. And so instead of using time and resources that they may not have had to fight their cases, they merely accepted the order. A large number of those people have been living peacefully and without incident in the United States for years, if not decades. While it was always a possibility that those who have been ordered removed would be subject to detention and eventual deportation, other administrations had prioritized other targets. Then in January of 2017, an executive order declared that it was the policy of the administration to promptly remove those individuals whose legal claims to remain in the United States had been exhausted. Whereas before, ICE and DHS were prioritizing those that they had determined were felonious and criminal and dangerous, the current administration has encouraged a scorched earth atmosphere, detaining any and all of those the law says are not welcome here. With that has come an uptick in removal orders. Federal immigration courts ordered 57,000 people removed in the first 6 months of 2017. That was a 31% increase from the same period the year before. Additionally, ICE has been making more and more detentions of non-criminal, non-citizens. In 2017, the fiscal year, they made 37,734 detentions of non-criminals. This was more than double the previous fiscal year. As we can see, the shackles have truly come off ICE. The many and varied reasons for someone to be ordered removed are not our topic of discussion today. And though that may seem sometimes that those who have been ordered removed may have no recourse, that is not the case. That's where immigration attorneys come in. We're here today to talk about motions to reopen, orders of removal, and getting your client a second chance at staying in the United States. We'll start with a brief introduction on how and when to use motions to reopen, then discuss the procedural nuts and bolts. We'll then talk about some sample scenarios in which when you might want to file a motion to reopen. And then finally, we'll give you some kind of practical scenarios, fact patterns to get you thinking about filing motions to reopen. So what is a motion to reopen? It's essentially asking for an opportunity to present new facts that weren't available at the time of the order of removal. Every non-citizen has a statutory right to file an order of removal at least once after they've been ordered removed. Although there could be many different scenarios, some of the most common grounds for reopening an order of removal include a change in country conditions, a change in family, a change in law. A motion to reopen may also be based on ineffective assistance of counsel or if the individual has survived domestic abuse. Your client may even have multiple claims or multiple bases to reopen their case. It is important to note that the motion to reopen must include any and all grounds for their relief. So the prima facie case demonstrating, for example, an asylum claim or cancellation of removal. As my esteemed colleagues mentioned in the last presentation, there are two forms of relief that come very close to each other in the Immigration and Nationality Act: the motion to reopen and the motion to reconsider. The motion to reopen is specifically for use when you have new facts that were unavailable at the time of the order of removal, whereas a motion to reconsider is essentially asking for the court to re-examine or to address an error that may have been made in fact or law. As I said, today we're focusing on motions to reopen. Now I'll turn it over to Nick, who will discuss some of the more procedural details.
All right, thank you, Alicia. So there are two main procedural requirements to focus on when filing a motion to reopen. The first is the numerosity requirement. And so, as you can see, we get one motion to reopen by a statutory right. And there are two exceptions, though, to this. The first being if you're filing a motion to reopen based on changed country conditions, there is no numerosity limitation. Additionally, if you're filing a motion to reopen as seeking relief as a battered spouse or child, there is additionally no numerical limitation on you filing a motion to reopen. The second big requirement is that, in general, you have 90 days to file a motion to reopen. So, and this is after the final order of removal. And as with the numerosity requirement, there is also a few exceptions to the timing requirement, the first being based on changed country conditions. There is no timing requirement for filing a motion to reopen based on changed country conditions. The second, for in absentia orders, instead of having 90 days to file a motion to reopen, you have 180 days. Or alternatively, you can also have no time limit, but in order to be eligible to have no time limit to file a motion to reopen an in absentia order, you have to show that you actually received no notice of the hearing where you were order removed. And third, if you can pull off a joint motion with DHS, there's no time restriction on that either. And then lastly,
What's DHS?
the Department of Homeland Security. And lastly, if you file a sua sponte motion to reopen with either the immigration judge or the Board of Immigration Appeals, there is no there is no timing requirement for that either. And so next, we're going to look at jurisdiction. So when filing a motion to reopen, you need to make sure you file it with the court that last had administrative control over the proceedings. And so to give an example of this, I have a sample timeline here. And so let's say it's 2009, your client today filed, or excuse me, your client in 2009 filed an asylum application or filed for asylum with the IJ, but was denied that relief. They then appealed to the Board of Immigration Appeals, and the board then affirmed the IJ's decision and also denied your client relief in 2011. And your client also happens to be from a country of origin where deportations just aren't really happening, either because the country's not accepting these individuals or it's just difficult for DHS to figure out the logistics of getting your client removed. And so your client is released on an order of supervision. And an order of supervision is when your client essentially is able to go out, they can work and they can do anything else, and they just have to report into their ICE officer at least once every 6 months. But they're still living under this order of deportation, so they can still be removed at any time. And so then in 2013, the country of origin that your client is from has like a regime change, and that regime change is adverse to your client. And now it's 2014, your client has come to you explaining all these facts about their case, and so you realize you can file a motion to reopen on their behalf based on changed country conditions and you essentially have a new asylum claim. And so because the BIA last had administrative control over these proceedings, you would need to file the motion to reopen with the Board of Immigration Appeals. And so I have a second timeline, same facts, the only difference is your client did not appeal that original deportation order. So I just want to highlight this because it's important. If you have a client here in Minnesota coming to you, they may not have been order removed by the immigration court in Bloomington. So it's important to research that and figure out where the final order was issued, whether it was in Florence, Arizona, or Omaha, Nebraska, because that is the court you will file the motion to reopen with. So next we're going to discuss the departure bar. The departure bar is a regulation that was promulgated that essentially said if your client leaves the United States either voluntarily or they're deported and they filed a motion to reopen, whether their motion to reopen if their motion to reopen had not been adjudicated yet, essentially their leaving the country constituted a withdrawal of the motion to reopen. And so essentially their claim died when they left the country. However, every circuit, but of course our esteemed Eighth Circuit, has overturned or found that this regulation conflicted with the INA statute. Some of the reasonings for some of the circuits for overturning this departure bar is that essentially Congress granted the statutory right to file a motion to reopen in the Immigration and Nationality Act. So this regulation was essentially the agency trying to curtail its own responsibility in hearing these motions. So if you have a client that was order removed here in the Eighth Circuit, it's still relevant until maybe somebody here can get that overturned for us. So next we're going to discuss just some basic filing fees. It's $110 whether you apply, whether you're submitting to the immigration judge or the Board of Immigration Appeals. There is one exception. If your basis for relief is exclusively based on an application for relief that does not require a filing fee, which would be asylum, withholding removal, or relief under the Convention Against Torture, there is no filing fee, but it's important to know it is exclusively. So if you include an argument based on any other grounds for a motion to reopen, then you will pay the $110 filing fee. Next, we're going to discuss some stays of removal. So when you're filing a motion to reopen, it's important to know that in a general immigration context, if you're appealing an immigration judge decision to the BIA, generally you get an automatic stay of removal for your client. But in a motion to reopen context, if you file a motion to reopen, there is no automatic stay or removal. And additionally, if you're denied a motion to reopen and then you appeal it, there is no automatic stay or removal. So it's important to submit a discretionary stay or removal with the immigration judge or the Board of Immigration Appeals. And so just some basics about a stay or removal is there is no filing fee when you're submitting one of these to the IJ or the BIA. Just kind of basic requirements, and this is straight from the immigration court and the BIA practice manuals. You know, they just ask for another recitation of the facts, which if you're filing this in conjunction with your motion to reopen, you can just incorporate the facts that you've already discussed in your motion to reopen. And the big thing about a stay removal is explaining the time exigencies involved. So how imminent is your client's removal? And so this is where things might depend if your client is in detention or if your client is out on an order of supervision. So if your client is detained, you might be able to articulate fairly easily that your client faces imminent removal because they're detained, so maybe ICE is working to deport them. But in the alternative, if your client is out and about, it might be more difficult to articulate the imminency of the removal. It might be a good idea still to file the stay. But the BIA manual also states that these discretionary stays are decided during the normal course of adjudication. And so they don't necessarily get decided any faster. So if something happens and you discover essentially that your client is facing imminent removal, maybe you've discovered a flight date in the coming weeks, you can file an emergency state of removal. The Board of Immigration Appeals actually has a hotline that you can call if you really are desperate for an emergency stay, if you don't have time to file more of a hard copy. And that's the same with the immigration court. You can call the court and request an emergency stay. The last thing I want to talk about for stays of removal is ICE has a stay of removal. So I just wanted to bring this up in case, if you're Googling this and looking at it. And so ICE, kindly enough, allows you to pay a $155 filing fee to ask the agency itself not to deport your client. The catch-22 to this is that they maintain the ultimate discretion in revoking the stay if they actually grant it. So they may grant it to you today but revoke it tomorrow. So depending on your situation, it might be an option, but it's just important to know that it's a little risky. So.
As a matter of course, would you recommend that be done in conjunction with the stay of removal with the IJ or the BIA, or more of an optional?
The ICE day? The ICE day is kind of like a last-ditch effort. So if you've maybe been denied your stay of removal already from the IJ or the BIA, it depends on what your client wants, right? But the real issue I think you see in that is just that ICE maintains the ultimate discretion. So it depends, I guess, on how ICE is feeling that day about your client. So I don't know if it's worth putting your client's life in their hands or not, but something to be aware of. So next, we'll discuss some appellate review. So the immigration judge and the BIA both have the discretion to deny your motion to reopen. So this is one reason why it's important to make sure you articulate what the new facts are that are available to you, and then the relief that is available to your client if their if their case is reopened. And of course, if you get denied, you can appeal. So if you get denied by the IJ, you can appeal to the BIA, and the BIA to the circuit of the immigration court that had control of the proceedings. So if you file it here in the Bloomington court, appeal to the BIA, get denied, and then you can file it to the 8th Circuit, of course. One thing, though, is that the standard review is abuse of discretion, so it's a difficult burden to overcome because you have to essentially show that the lower court's conclusion was not justified by the evidence presented. So something to keep in mind. Lastly here, I just have a short little checklist of just some stuff to make sure that you include when you're filing a motion to reopen. So of course, you always have to include your notice of appearance, filing fee if necessary, kind of a no-brainer, but all the supporting documents and evidence, like affidavits and government reports related to your motion to reopen. I think most importantly is the 4th bullet point, which is including a copy of the application for relief and supporting documentation for that relief in your motion to reopen. So if you're applying for asylum, you need to make sure you include that I-589 application in there, because you're trying to make that prima facie case to the court that relief is available, and here it is, reopen my case because the relief is right here and you can see all the documents supporting that. And of course, you have proof of service. And then if your client has recently moved, just making sure that's updated with the court. And then lastly, filing that motion to stay removal. So next, I'm going to turn it back over to Alicia here, and she's going to start giving us an overview of some of the grounds for removal, or excuse me, grounds for a motion to reopen.
Thank you, Nick. So as we've kind of mentioned earlier, there's quite a variety of grounds to reopen an order of removal. We'll talk a little bit today about a change in country conditions, if your client has been ordered removed in absentia or while they're not there, if there were any due process violations or a change in criminal status, ineffective assistance of counsel, a change in family circumstances, and changes to the law. If the country conditions of your client's or country of origin have changed substantially, your client may have the opportunity to apply for asylum or withholding of removal or under the Convention Against Torture, and this would allow them to file a motion to reopen. This right to file a motion to reopen is granted in statute. And as Nick discussed, there are no time bars or limits to the number of motions to reopen you can file based on a change in country conditions. So this might apply for someone who, say, is from Syria and was ordered deported in 2008. And here we are in 2018. Conditions in Syria look quite different than they did in 2008. So there may be the opportunity to present new information that was unavailable at the time of that order of removal. Since courts do prefer finality, and this particular ground to reopen an order of removal is granted in statute, this particular exception must be based on a change in the country condition rather than a change in, say, your client's personal situation. So in contrast to the Syria example I gave, here again, you might have a client from a country that treats a religious minority group differently, but that, or adversely, persecution, for example. And at the time of the individual's order of removal, that was the case, and it's the case now, but your client has since converted to that religion. In this case, your client would not have the opportunity to file a motion to reopen with a changed country condition, but there would be perhaps alternate relief available that Nick will discuss a little later on. Some other things to remember about filing a motion to reopen based on changed country conditions. If a previous asylum claim was found to be frivolous, an applicant may be barred to file a motion to reopen again. Although a negative credibility finding does not preclude a client from reopening, so that's good. And like Nick has mentioned before, it is important to include the entire application for relief, the asylum claim, the withholding claim, and the CAT claim. So these motions tend to be very long and very detailed. So if you're thinking you can file one in a day, that's probably not true, unless you've got everything ready. Now we'll talk a little bit more about what to do if your client was ordered removed in absentia. A person who fails to appear at their removal proceedings may be ordered removed in absentia while they're not there, right? These orders may not be appealed directly to the BIA. Instead, you do have to definitely go back to that same immigration judge who ordered them removed. And you have to include the reasons why your client did not appear. If you file within 90 days, it's a matter of merely explaining this is what happened, and you would ask the immigration judge to rescind the order. If you are filing this motion to reopen 180 days after that order, you must demonstrate that the client's failure to appear was due to exceptional circumstances. The decision as to what an exceptional circumstance is very fact-specific and is often inconsistent among the circumstances. Something that might be considered an exceptional circumstance would be an illness with supporting documentation, perhaps an illness or a death of a close relative, a parent, a spouse, a child, things of that nature. Depending on the circuit and depending on the judge, of course, you may have the ability to say, look, we live in Minnesota, we had 3 feet of snow, my client couldn't get there, and that might be considered exceptional circumstances. It is based kind of on a balancing test that the judge will do. The timeliness of the filing of the motion to reopen, what your client did to alert the court of whether or not they were going to be there, the strength of the respondent's underlying claim and any harm the respondent would suffer if they were in fact denied this motion, and then of course government inconvenience. If the client has received no notice of their hearing, then there is no time bar. But if they merely failed to provide a change in address or ignored a notice, then they may be out of luck. It is on the burden of DHS or the government to show clear and convincing evidence that there was proper service of this notice. Next, we'll talk a little bit about attacking kind of the basis of the order itself. Sometimes it may be possible to attack the fairness of an order. coming from a due process violation, or if, for example, there was a vacation of criminal charges, or there was ineffective assistance of counsel. If you think that there was a due process violation within the removal proceedings, you would have to demonstrate that there was fundamental unfairness in the deprivation of the opportunity for judicial review, that you've exhausted your administrative remedies, and again, that fundamental unfairness underlying the removal order. Another example might be if your client was ordered removed based on a criminal charge that was later vacated. For example, if your client was ordered removed based on an aggravated felony or a controlled substance conviction or something of that nature. If they were later exonerated or those charges disappeared, it may be possible to reopen the order. Now, we all like to think that we are perfect and we do not make mistakes as lawyers because we're right all the time. It's unfortunately not true. And sometimes these mistakes that we make do have adverse results for our clients. If that happens, later attorneys can challenge an order of removal based on ineffective assistance of counsel. For example, in one case, a woman was ordered removed based on claims that her marriage was fraudulent and that she had falsely represented herself as a U.S. citizen. The BIA held that her attorney's failure to introduce substantial evidence regarding the genuineness of her marriage, and by not asking for a review of the USCIS's denial of her application, was prejudicial. Be assured that your representation doesn't have to be brilliant. It just cannot make it so fundamentally unfair that the non-citizen was prevented from reasonably presenting their case. If you think that your client was ineffectively assisted, you would file one of these motions in thinking about the Lozada framework, which is a case from 1988 from the BIA, which set the standard for ineffective assistance of counsel claims. Within your motion to reopen, you do have to include an affidavit, including the agreement between the attorney and the client. You do have to show that you informed counsel of this complaint, and the motion must also reflect whether or not a complaint has indeed been filed against the attorney. There may be no time bars or different time bars depending on whether or not your client has been a victim of ineffective assistance. So if, as soon as the client demonstrates that they had ineffective assistance of counsel, the deadline to file that motion will start tolling. Alternatively, if your client was a victim of fraud, they were not in fact represented by an immigration attorney at all. Someone lied about it. There is most likely no time bar at all. Now, Nick will discuss asking the immigration judge or the Board of Immigration Appeals to use their discretion to open orders of removal sua sponte.
So, sua sponte motions are a little bit different than anything else because sua sponte motions don't necessarily have a blueprint to always follow. But sua sponte motions, I think, now are probably more relevant than ever, partly because there's been a lot of clients that have been released on orders of supervision from countries that we've discussed, such as Somalia, Iraq, Cambodia, and Haiti. And the removal was never possible, maybe until recently. And so some people have lived here for years, if not decades. And in that time, they've gotten married, they've had children. And so their own personal circumstances have changed tremendously. And that doesn't necessarily fit into any of the statutory grounds for reopening a case, such as, changed country conditions. And so you may have an opportunity to try to get a case reopened sua sponte. maybe based on like a family change or a change in law, even if it's been several years and the law is always changing, and the grounds for why your client was removed may have changed, essentially. And so a sua sponte motion is when the immigration judge or the Board of Immigration Appeals, they have the ability at their own will to reopen a case. And this is also stated in the regulations that the courts have this discretion to reopen cases. And so first we're going to discuss just a family change. So as I stated, a lot of individuals, clients, maybe lived here for years and gotten married, so they might be eligible for adjustment of status through their spouse. Now, having a sua sponte motion based exclusively on a family change probably won't be worthwhile. That's in part because your client was more than likely order removed on some grounds, and for the reasons that they were order removed, such as like what's most commonly like a criminal conviction, it might bar them from adjustment of status. And so usually a family change is just an element of your relief available to you through a sua sponte motion. And so this usually falls in conjunction with a change in law. And so for a change in law, you need to show that the change was fundamental in nature. So essentially, it's completely flipped 180 on what it used to be. So for example, for criminal drug convictions, over a decade ago, you could have been found removable as a drug trafficker or aggravated felon if you had just two simple drug possessions that were separate and they weren't even, you weren't charged or convicted as a drug trafficker, but under the INA, they could find you as a drug trafficker and therefore deportable. Since then, there was a case called Matter of Carretera Rosendo that changed that and said just two simple drug convictions for possession, does not make you a drug trafficker unless you were actually charged and convicted as a drug trafficker. And so, for example, you could blend this change in law with maybe relief available to your client, whether that be a family change, if maybe your client has gotten married because they've been out on order of supervision. And so you can show this change in law in conjunction with the family change, and then to show your client is eligible for relief. Alternatively, maybe your client is from a country where they would be eligible for asylum, so that same change in law works in conjunction with changing country conditions. And so there isn't a perfect blueprint for these. It's a little bit of a mix and match. And there's other grounds as well for trying to do a sua sponte motion, as we aren't going to discuss in this presentation, but for example, if you're trying to apply for relief as a battered spouse or child, that's another reason. So I just wanted to highlight again, now that we've discussed at least the grounds here today, just to remember that the BIA and the IJ both have their own discretion in granting or denying these motions to reopen. So that's why it's important to articulate the new facts that have become available since the final order removal was entered, and then making sure that you show the relief that is available to your client. So whether that's through changing country conditions, if it's an in absentia order, you're showing the exceptional circumstances that kept your client from attending. And then alternatively as well, if there's been a change in law, maybe a change in familial circumstances, to show that relief. And just to review again that if you're denied, the standard review on appeal is abuse of discretion. So now that we've discussed these, we have a handout that should have been included in the materials that you received. It should be one sheet, I think, front and back with two sample scenarios with a client 1 and a client 2. And so we're going to ask that at least this side of the room try to focus on client 1, and then this side of the room focus on client 2, and just reading the facts and answering the questions. I will say for those doing client 2, we had a last-minute alteration this morning with that scenario, and so some of the facts changed, so I have them in the slide. Don't look at that. All right, sorry. Anyway, in red is what was changed based upon what you have in front of you. So hopefully that's clear. If not, we'll just try to breeze through the questions. I can lead the discussion on that if necessary. So take about 5 minutes to kind of look through everything, and then we might take about another 5 minutes to ask you, kind of work with somebody close to you to discuss, and then we'll reconvene as a group and discuss both scenarios. I think we're going to go ahead and reconvene as a group, if that's okay with everybody. Or do we need some more time? I don't know. I'm trying to read the room here.
If you need more time, raise your hand. Great.
All right, so because we're already on client 2, Salah's facts, we're going to start with him. And so for the questions then, do we have a volunteer that would maybe like to summarize these facts real quick for us? Anybody bold enough? That's all right.
Okay, go for it.
Okay, thank you.
So we have an Iraqi national who came here in 97 as a refugee, was granted adjustment status. He was then arrested in Des Moines, down in Iowa, for some possession of cocaine and meth. So I'm kind of bringing up the slide, but so he had these arrests, served a year in jail, was convicted of, or ordered removed as an aggravated felon, and his LPR status was revoked, but because of his Iraq, it looks like he didn't appeal, or he was ordered released on an order of supervision, and he didn't appeal his case. And so now there's some changed circumstances. He has a girlfriend and 2 U.S. citizen children, and the children are still minors. Looks like he was picked up by ICE and is facing imminent removal. And there also seems to be some change in law that could help his case, given the aggravated felony status that was initially ordered removed.
All right, thank you for that. Would anybody like to answer the first question up here then of where would a motion to reopen for Salah need to be filed? Yes, sir?
Would it be wherever the order for removal was issued?
Yes, it would be. So we know that he was order removed by an immigration judge. We don't really know where that immigration judge was, so we have to figure out which court ordered him removed and file that motion to reopen with that court then that issued his final removal order. And so for the second question then we have is, can a motion to reopen based on changed country conditions be filed for Salah?
Anyone bold enough to say yes or no? Great.
Yes, we have a yes. So I think that is possible. So of course in our small fact pattern here, we don't really say, what's happened in Iraq. Of course, maybe in your own personal knowledge, you might know that there's been a few changes in Iraq since he was order removed in 2006, such as like the rise of ISIS, and then, just overall instability of government. So I think it's possible. So we know then maybe it's possible to file a motion to reopen on his behalf based on changed country conditions. So for question 3 then, if a motion to reopen is an option, then like what relief is available to him currently then? Is anybody bold enough to answer that question? That's fine. No worries, it's already Tuesday afternoon here. So we know because of his, oh, yes, there's a question?
Just reading ahead, you said that it's aggravated felony makes him ineligible, but I thought now we're saying it's not an aggravated felony. Is it the fact that he was charged as an aggravated felony, but the case law is now that it isn't?
Correct. And so if we're looking at it for the lens of just before looking at the change in law, so I'm sorry, I guess maybe the question could have been clear, was that if we're not looking at the change in law yet, but we're just looking at relief based on changed country conditions, you would be right that he would be barred from asylum because of his aggravated felony, but he could still apply for withholding of removal or under the Convention Against Torture. So that kind of leads us into the next question then of can we file a sua sponte motion on his behalf based on this change in law? And so I guess I'll just follow up with that and saying, yeah, I think we can, with the Karachuri argument that his 2 possession convictions are not actually, or he was not convicted as a drug trafficker and then therefore has an aggravated felony based on those convictions. So then therefore he is eligible for asylum still. And so then fifth, yes?
How would you address that was 2010 and now it's 2018? What would you recommend?
So for the change in law?
Yeah.
So, right. So you would just articulate then the facts of the case of the Carachuri-Rosendo argument in 2010, and you show that he was convicted of those 2 simple possession charges back in 2006, I think, right? Is that what I have?
2006.
Okay. Yep. And so you give the procedural history of when his convictions occurred in 2006, and then you explain in 2010, after his conviction, or I guess, excuse me, backtrack one moment, you show his convictions in 2006, and then his removal order, and the explanation for his removal based upon the fact that he is a quote-unquote drug trafficker based on those 2 simple drug convictions. And then you show the Carachuri case, and so how the BIA decided, no, actually those 2 simple possession convictions don't constitute drug trafficking unless he's actually convicted of drug trafficking. So it's not an aggravated felony. And so since we know then that he did adjust his status originally and then it was revoked based upon this conviction, with the Carachuri argument, then he would be eligible then to reapply for adjustment and therefore wouldn't be barred from also applying for asylum.
I guess I'm sorry, I'm
Sorry.
referring to, have you seen any examples where the court sees, yes, but that was 8 years ago when there was a change in the law, and here you are in 2018 asking for that, or that's not really?
No, it's still new to your client's case. You know, he hasn't presented a motion to reopen yet. So, and still that sua sponte, you know, this just happened, so. Mhm.
I think there is an issue for the BIA and the court around due diligence following the change in the law. I think that's just pointing out, if you just wait all this time, like if you bring like a St. Cyr argument now, the court's gonna ask, where were you 8 years ago? So I think you have to demonstrate in some way that equitable tolling here should apply, or that there's some good reason for the delay in bringing this case. I think Convicta might be kind of a code for that, but I mean, I think it's still going to be a little challenging in this situation.
Okay, thank you for your input, John. I appreciate that. So lastly, or I guess a 5th question we need to answer then is he going to pay a filing fee then if he applies for a motion to reopen based on sua sponte? Yep, he's going to pay the $110 fee. And lastly, do we need to file a motion to stay removal for Salah? Anybody want to give a yes or no for that?
Good idea. Maybe not.
We got a good idea, yes. So I say, go ahead. Maybe not. I mean, I guess you do it just because it's your responsibility as the attorney to make sure you do everything for your client. But it might be hard to articulate the imminency of his removal because in this fact, he's still out on an order of supervision, so you have to be able to show that removal is going to... Yeah.
Could there be an unintended consequence to filing it?
I don't believe so. I think that you just file it and it may just get denied, so you may have to file another motion to stay his removal if the imminency factor happens. So I don't think there's there's nothing really hurting you from filing it. It just may not be granted.
It couldn't shine new light on your case and therefore you are detained?
I'm sorry, excuse me?
Could the fact that you're filing the motion bring new attention to your case, and even though you had been released under order of supervision, could you now be detained?
You know, I don't know personally if that's the case or not, so I don't know, maybe somebody else could. I don't know if anybody else in this room has experience with that.
So, I haven't heard of that happening. I haven't heard of an EOIR filing, as long as the person's on a valid order of supervision. We're not talking about someone who was absconding, right? If the person is on a valid order of supervision, I have yet to hear that a filing of a motion to reopen with a stay will trigger them recalling the order of supervision. That I've not heard. Of course, this is a new administration, so I don't know whether that would be, and that would be something you would need to weigh. I do think the issue, though, is once the case is reopened, and if the person would be mandatorily detained under 236C, right, then even if your client gets their case reopened, they could re-detain him, right? So if they have, for instance, in this scenario, even though it's no longer an aggravated felony, drug trafficking, it's still mandatory detention, drug case, so if it gets reopened, he could be re-detained under 236C. Now, again, that wasn't necessarily happening before, based on resources, but that could technically happen. But I have not yet heard of someone having their order of supervision revoked specifically because they filed a motion.
I think we're running out of time, so we can quickly fly through the answers then for client 1. I guess in case anybody was curious to know.
Or we could say, are there any questions about client 1?
Well, I guess we'll end it with, were there any questions about client 1 anyway? So we at least have some time for final questions here. Okay, that's fine. Does anybody have any questions just in general for us?
I thought that you had said, I may have misunderstood, that in order to proceed on inadequate counsel ground, that you need to make a complaint. But I didn't understand the details. Complaint to whom, or what kind of complaint? Is that a requirement for the filing, or?
Yes, so whether, the question was, when you're filing a motion to reopen based on ineffective assistance of counsel, whether or not in your motion you had to indicate if you'd filed a complaint against the attorney, and that would be a complaint to the local bar, and it's not necessary to file a complaint, but it's likely a good idea if you're going to base a motion to reopen on it. Yeah, so you'd have to, like I mentioned, there's within the motion, you have to outline the agreement that was made with the client and the attorney, what didn't happen, and then whether or not you filed a complaint with the bar, and, excuse me, whether or not you had informed the counsel of it. So that's what the case law indicates that you have to include in the motion. Oh, where?
Oh. I have a simple suggestion for you. I had a client who was detained. I thought we had I worked on the case with another lawyer. I thought we had a very good strategy, but what happened was, in the meantime, he was locked with other just U.S. citizen felons, and the condition inside the jail was so bad. He said that, your strategy sounds wonderful. I want to stay in this country, but the whole thing is bullshit. I cannot stay here anymore with these felons. So he made a voluntary departure. I made a strong argument with the jail, officers and things like that. They said, under the circumstances, we cannot make any exceptional case for your client just because he's a foreigner and things like that. So I thought maybe in the future, if you have any opportunity, let's pay some attention to these foreigner detainees who didn't deserve to be, mingled with felons in this country.
Okay, thank you. We had a suggestion to think about what the potential effects of detaining a non-citizen with the criminal population. And that's a great idea to think about and try to work out with our clients. Any other questions?
Kirsten's got closing remarks.
Oh, okay. Well, we'll turn it back over to Kirsten for some closing remarks. Thank you very much, everyone.
Thank you, everyone. I just wanted to show my gratitude for having this conversation with you today and learning more from our students. And it is a special thank you to our students because they were crazy enough to choose to add additional work to their clinical work and take on this opportunity to lead a continuing legal education. seminar. So yes, thank you. And I would also like to thank Liz Caulfield, who you probably met in the entrance. She helped put on all the logistics for today, as well as to Depinder Mayel, who helped our students with the content and with their presentations. So please don't forget to leave your evaluations at the front desk so that our students can learn from that and have a safe drive home.